Yes, Mulad, this is
Getting
my,
for?
but I'm for the appellant.
Yes. It is your extension of interim order.
Lordship,
Or I am for the plaintiff landlord.
So can two is whose application?
not our application.
So can two is to be disposed.
Yes.
So affidavits are complete.
Well, we have filed our affidavit long time back, but till date it seems to be there seems to be no reply in respect of my opposition, my lord. So therefore, my lord, I can safely say that they have accepted whatever we have stated in our
But
affidavit.
we have not, Mulad, but in this matter, Justice Mulad, Bibhash Ranjan De Mulad, was pleased to fix the main appeal for hearing. But on 2-3 occasions it was extended and the main appeal was fixed for hearing.
The paper books are ready.
Everything ready.
Before that, lordship, they are enjoying an order of stay as per the Honorable Supreme Court's dictum. My lord, they have to pay occupation charge as per.
Have you taken out any application with regard to that?
My lord, in the stay application itself, we have stated so in my opposition, and they are bound to follow the.
So if you want,
only
you can
one
file
thing.
your reply. I'm giving you.
But
by
only
next
one
week.
thing, Millard. That is all right, Millard. We bow down to your lordship, Millard. But when the appeal is ready, it's a very short appeal. But the appeal itself can be heard and disposed.
That is the other aspect of the matter,
But
lordship.
they know very well.
Lordship, they are enjoying stay without making any kind of payment, which is contrary to the dictum of the Honorable Supreme Court. They cannot enjoy the property. They are carrying out business.
They
are
know.
carrying out business without paying anything. They are enjoying the property and enjoying the stay order.
Record an order.
My client is a maid servant.
Learned advocates for the parties are present. That this application for stay can 2 of 2023 be listed on. I'm keeping it on Wednesday. You file your reply.
Malad, 1 week time at least, Malad, I require, Malad.
On 8.
Malad, may I take your lordships to 1 or 2 orders of Justice Bibhash Ranjan?
Whatever it is, I'm extending your interim order.
No. Malad, kindly have a look at the order.
Yes, if the appeal is ready for hearing, I shall hear it.
Yes.
But you are enjoying the property. Let us consider your stay application and their plea for occupational charge.
Malad, kindly appreciate.
How much rent are you paying now?
Nothing.
No, my lord.
It's at Shambajar. 240 square feet used for, my lord, commercial purpose.
No. Rent was the last paid. How much was?
250. And we have claimed that the occupational charge as per the market value based on a report will be 13,000 per month. And he's liable to pay from the.
I'm keeping it on 8/1/2025.
Malad, kindly list the appeal on 8th. We will do the appeal.
Actually, you see, hearing of the appeal, it is not possible now because there are.
It's a very short point.
Whatever it is, you see, there are other second appeals which have to be heard out.
Malad, kindly keep
definitely, I shall keep it, but not with this month.
Very well,
8/1/2025 for hearing of this
8/12, lordship. 8/12.
Yes, 8/12.
8/1/2025.
Yes, under the same heading, the reply, if any, to Can 2 of 2023 be filed in the meantime.
And lordship, the interim order has been extended till?
The interim order stands extended till 12/12/2025 or till further orders, whichever is earlier.
This will create another confusion.
No, my lord, it will not create any confusion.
Very well.
My lord is very clear about my lord's direction.
But in November, this was supposed to come up on 7th November 2025.
You see, now I have so many matters for hearing. Actually, it is difficult to hear second appeal now.
Financial condition, they are always pressing for the occupational charges.
Yes, that
they
is
don't want the appeal to be disposed of.
See, appeal will be disposed definitely maximum 2 months, 3 months, not before, not after that. Definitely within 3 months, appeal will be disposed. But let us consider their prayer also.
Very well.
I'm so grateful to you, Lord.
In this matter, what had happened, I filed the appeal challenging the award and they filed a cross objection. And on their prayer, they relied upon some income tax return of the claimants, and that the matter was.
No, this is your appeal. The Can 1 is disposed.
Yes, Can 1, a paper book has been filed, but at the midst of hearing, they wanted to rely on some income tax return of the deceased, which they could not corroborate before the learned tribunal. The Justice Ananda Bandyopadhyay was pleased to remand it back only to that point, and they had adduced evidence and it has come back with the TCR. So it can be heard out any day by your lordship.
Yes, record an order. Learned advocates for the parties are present. it is submitted by the learned advocates that the matter is ready for hearing. As this is a claim case and the matter may be settled, the matter is referred to the National Lok Adalat to be held in the month of December. Fix 8/1/2026 for report of the National Lok Adalat and further orders. You are for the insurance company. You see if your client wants to settle.
Lord, I my lord, I am the claimant respondent. My lord, at my instance matter is appearing before your lordship. My lord, I have twofold prayer. First one is
The matter is ready for hearing.
yes, the matter is ready for hearing. My lord, lordship.
These applications are all disposed.
All the applications are disposed. My lord, stay. I am victim of stay order.
Yes.
My lord, actually, what happened? My clerk, my lord, wrongly deposited the 7 set of paper book at the department. My lord, actually, lordship kindly record an order so that I can collect it from this court. 3 copies are required, my lord. One for my learned friend, one for myself, and another for another respondent is there. 3 copies are required. Lordship kindly give me leave to collect this, and lordship fix up this matter.
It is their appeal, your appeal, this one.
His appeal.
So you see if it can be settled. I'm sending it to the Lok Adalat.
I have challenged the involvement of the vehicle in the accident. The chances are
Whatever
very.
it is, you take instructions. If it is, you see, if it is not
Actually,
settled, I'll hear it in the month of January. Yes, record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that the matter is ready for hearing. Thus, the paper books which are filed by the department be put up before this court. Stop. However, in the meantime, as this is a motor accident claim case and the matter may be settled, the matter is referred to the National Lok Adalat to be held in the month of December. Fix 8/1/2026 for report of the Lok Adalat.
Lordship kindly give me leave to withdraw the paper book, 3 copies
Yes,
of
yes. Let it be put up first. If they let this paper book be put up before the court.
Lordship. Then what I am praying, my lord, in the meantime, after receiving the paper book from the department, in the meantime, let it be again appear in under
the month of January. I've kept it in the month of January. 12th, the Lok Adalat will be held. If it is settled, well and good. Otherwise, a month of January.
My lord, main predicament is this, my lord.
Yes.
The claimant before your lordship, one is the widow and another is the mother. My lord, who is on deathbed. If the matter
That is why you see, if it can be on 12th, it will be held. If it is can be settled, well and good. Otherwise, I'll take it up in the month of January.
lordship, then lordship kindly collect the paper book.
The liberty is granted to the learned advocates for the parties to collect the paper books.
I am grateful, my lord. I am grateful.
After they are put up before the court.
My lord, actually, I don't know what will be the consequential effect at the Lok Adalat. It may be, certainly it will come back.
Your learned friend will take instructions. If the insurance company is willing to settle, the matter will be settled. You will get the amount immediately.
If my learned junior so agree.
Yes, yes.
I'm grateful, my lord.
Bless your lordship.
My lord, item number 6 to 10. I am for the petitioner, my lord. I am bringing short passover, my lord.
Okay, short passover.
My good, please.
Because you see, up to 12, these appellate side matters will be taken up.
After?
Up to 12.
Okay.
Because after 12, original sides. So try to come early.
My lord.
6 to 10 passover. This is my application. So is it a part-heard matter?
Yes, it's a part
Part-heard
matter, my lord.
by me?
Yes, my lord. It was sent for the mediation. There is a point of, my lord, limitation 468, 469. There is a simple, my lord, agreement between the parties. And if
Matter is sent before the mediator. Report has come.
mediation, yes, probably come.
Yes, I'm appealing for the opposite party.
Let me see the
mediation
report.
report has come. I think mediation has failed.
Mediation failed.
Lordship, may I kindly keep the matter anytime next week? I'm led by Mr. Shobhashachar.
Then, my lord, extension, my lord, I filed the, my lord, in time, my lord, the extension.
Lordship, may I kindly keep it on Monday or Tuesday?
Any day, my lord, but
But it is going to expire.
it is going to be expired on. It is. The court in view amicable. There is stay all further proceedings pending before the London Court, Calcutta, 4 weeks after vacation. It is filed in time. My lord,
Kindly keeps it on Tuesday. We will do the
my
matter.
lord,
Your Lordship.
let the interim order be extended, and my lord, any day can fix.
Just record an order.
Your Lordship, then kindly extends the interim order till that date itself, Your Lordship.
Learned
That is up to
advocate
you.
for the parties are present, hard learned advocates on the prayer of the learned. As the matter was sent to mediator and the mediation proceedings have failed, this matter should be taken up for further consideration and hearing. Let this matter appear on 3/12/2025. The interim order granted earlier stands extended till 12/12/2025 or till further orders, whichever is earlier.
I'm good.
Yes, my lord. My lord, I heard the petition, and my lord, your lordship, on the earlier occasion yesterday, my lord, your lordship could have remembered, my lord, the affidavit of service was not with me. Your lordship passes the order, my lord.
So that there is section 5 application.
Yes, my lord. My lord, yesterday, my lord, my matter was as.
So what is the affidavit of service?
Yes,
You have served upon all the parties.
Yes, my lord.
Yes.
My lord, opposite party number 2, I have served the state as well as the opposite party number 2.
Yes, state you have served the PP.
Yes, my lord.
And
I have
regarding
served.
opposite party
And
number 2?
regarding opposite party number 2, may I submit, my lord? Through speed post, my lord, through DTDC Express Limited, I served, my lord, the track report, my lord, due to some server issue, my lord, I don't get. My lord,
No, DTDC
through
is this
email, my
courier. DTDC is
yes,
courier.
yes, my lord. My lord, through email I have sent, my lord. Since
Email you have sent.
yes, my lord. Last page, your lordship kindly sees, along with entire copy, my lord.
Yes, record an order. How many days delay?
My lord, 90 days, my lord.
90 days.
Yes. My lord, your lordship, yesterday your lordship passed the order, my lord.
Yes,
As
please.
item number 21 and 22, my lordship
Just a
already
minute.
passed the order. Only it was made as not today, yesterday, my lord, since I didn't get the affidavit of service with me.
Yes. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. The application CRAN 1 of 2025 is taken up for consideration. Stop. As the petitioner has served both the opposite party number 1 and opposite party number 2, and none has appeared on behalf of the said opposite parties, the application for condonation of delay is taken up for consideration. Upon perusing the application, and did you find, where is that CRAN?
Yes, my lord.
CRAN টা দিন তো ট্রান অ্যাপ্লিকেশনটা দিন আটের মধ্যে yes it appears from the application being CRAN 1 of 2025 that the petitioner after the impugned order was passed applied for certified copy, and upon obtaining certified copy due to his ill health he could not take steps to prefer this revisional application. Stop. Thus, there is a delay of 90 days. Upon hearing the learned advocates and considering the grounds, this application for continuation of delay stands allowed. The application under section 482/401 of the Code of Criminal Procedure, read with section 528/442 of BNSS 2023 is taken up for consideration. The petitioner in the instant case has challenged the order dated 24/4/2025 passed by the learned judicial magistrate 8th Court Calcutta in CS 14460/2020. The learned magistrate in the said order directed the petitioner accused to pay interim compensation, which is 10% of the check amount. Stop. The grounds cited in the said order is that the petitioner delayed the said complaint case. Stop. Learned advocate draws attention to the complaint petition and submits that the check amount mentioned in the
Paragraph number 10, my lord.
complaint petition in paragraph number 10 does not tally with the check amount mentioned in the order passed by the learned magistrate. Stop. In paragraph number 10, the check amount is rupees 17,63,288, and in the order of the learned magistrate, the check amount is mentioned as rupees 1,42,50,000. Stop. Thus, there is an error in the order with regard to the quantum of interim compensation. Stop. Moreover, it appears that the learned magistrate has not given the details on which the accused petitioner has sought for adjournment, as from March 2020 till February 2022 was the COVID period. Stop. And the case was ready for evidence of the complainant. Thus, considering the grounds and upon perusing the order dated 24/4/2025, this court is of the view that this application should be admitted. Thus, I admit this application. Let's notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear.
My lord, may I submit one thing, my lord? My lord, yesterday, my lord, your lordship was pleased to grant me a stay, my lord. My next date is 14th of January, my lord.
Please wait.
Yes, sir.
Let this matter appear on 22/12/2025 before the learned regular bench. Stop. Pending hearing of this application, there shall be a stay of the order dated 24/4/2025 passed by learned judicial magistrate 8th Court Calcutta in CS 14460 of 2020 for a period of 1 week from the date of reopening after Christmas vacation.
Yesterday, my lord, your lordship was pleased to give, my lord, 3 weeks after vacation, my lord, winter
Let it
vacation.
for a period of 2 weeks. When is the next date fixed?
14th of January.
Then for a period of 3 weeks from the date of
Grateful,
reopening
ma'am.
of the court after vacation.
I'm grateful, ma'am.
No. Matter to appear before the regular bench on 22/12.
Grateful. My lord, 14, my lord, same matter, my lord. The petitioner, complainant, both are same, my lord. Only the CS number is different, my lord.
Let me see the
Yes,
record.
my lord. CS number is, my lord, 14459.
Now, what is the ground of challenge?
My lord, the same thing, my lord. Your lordship kindly comes to the impugned order, my lord. Impugned order dated, my lord, same 24/4/2025, my lord. My lord, kindly see the last paragraph, my lord. It suffers from irregularity, my lord. Comes to the page, paragraph 10 of the NI Act complaint. Your lordship will find the irregularities.
No, here the check amount is correctly mentioned. There is no dispute with regard to that.
My lord, it is, my lord, 14250.
No. Where is the check amount in the complaint petition?
My lord, the complaint petition, the check amount is, my lord. Your lordship kindly come to.
1 crore? No, it is.
No, my lord, it is, my lord, 1,50,000. Your lordship kindly comes to
No. Pay paragraph 10.
paragraph 10 and paragraph 8, my lord. In
Okay.
paragraph 8, it is said that 150,000, my lord, 1,50,000. And paragraph number 10, my lord, it said 1,42,50,000.
And how much you have to pay?
My
It
lord,
is only 1 lakh.
also, my lord, the check
Here
was
also you see. No, I think this is the matter. Okay. But here it is
My lord,
just the opposite.
My lord, the security check has been given by the petitioner to the
No. You
complainant.
see, here it ought to have been more. You see, 1,42,50,000. Okay.
Yes, ma'am.
So, but here the mistake is the landed magistrate recorded is 17,63,000.
Yes, my lord,
So,
17,63,000.
so the grant of compensation is nothing more.
My lord,
Although there is a mistake,
there is a mistake, my lord. My lord,
that means you are directed to pay less.
my lord,
If that is to be followed,
may I
then
submit, my lord, may I
yes.
submit? My lord, the check, what has been given by the petitioner to the complainant, my lord, that was a security check. That was issued to the complainant, my lord, for the purpose of assurance.
That will
my
be
lord.
decided at the time of trial. But where
this
is the error on the face of the order?
This impugned order has been passed, my lord, at the verge of the commencement of trial. Your lordship kindly sees the.
Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. This application is directed against order dated 24/4/2025, passed by learned judicial magistrate, 8th Court, Calcutta, in CS 14459 of 2020. Top. By order dated 24/4/2025, the petitioner was directed to pay interim compensation of the check amount amounting to rupees 1,76,328. Stop. It is submitted by the learned advocate that when the trial has commenced, the order for payment of interim compensation was passed. Stop. It appears from the order dated 24/4/2025 that the learned magistrate has assigned reasons of the delay caused by the petitioner accused in getting the matter heard. Top. Although the reasons are furnished by the learned magistrate, but considering the fact that the matter was ready for trial, and from 2000 February 2000 March 2020 till February 2022 was the COVID period. This court is of the view that this application should be admitted. Thus, I admit this revisional application. We আগেরটার মতনই করে দেবেন, notice be issued upon. Okay, same date.
Yes. I'm grateful to your lordship. My lord, in respect of this one also, I have filed the affidavit of service, my lord.
So here there is also a
Yes,
grant.
my lord, same day,
No,
90
here
days.
also.
Yes, my lord.
আচ্ছা ওই CRN আগে যে অর্ডারটা হয়েছে ওই একই অর্ডার করে দেবেন।
In respect of CRAN, I'm grateful to your lordship.
বলতেছি ক্র্যানের একটা অর্ডার হবে, ঠিক আছে? ওটা তো ক্র্যান আছে, দুটোতেই ক্র্যান আছে, দুটো ক্র্যানই ওই একই অর্ডার।
Grateful, my lord.
My lord, I am appealing on behalf of the petitioner, my lord. In this matter, my lord, we have filed a CAN application for the extension of interim order, my lord. The matter has been heard prolonged by your lordship, my lord.
So for the petitioner,
Yes, my lord. My lord, the matter may be taken at 2 p.m., my lord?
the 2 p.m. Anyway, if the other side is present, I can take it up at 2 p.m.
No, other side was present, my lord. Other side was present, my lord.
So let it be passed over.
Can we fix at 2 p.m., my lord? Then my lord, I am praying for not today, if it is not possible.
Okay, not today.
Sure, much obliged. My lord, the extension can we?
No, when will the order expire? Interim order. We ascertain come on Monday.
My lord, my lord.
My lord, this is my application, my lord, seeking setting aside of the order dated 20th November 2024, my lord, which arises out of the petitioner before your lordship is a defendant in a eviction suit. Now, my lord, what the learned court has done, my lord, learned court has gone by the presumption under section 27 of the General Clauses Act, my lord, without complying with the provisions of the Order 9, Order 5, Rule 9, Order 5, Rule 9A, Order 5, Rule 17, and Order 5, Rule 19 of the Code of Civil Procedure. My grievance is that, my lord, since there is a specific finding to the effect that summons have been served, which has in fact not been served upon the defendant, my lord, my defense will be struck off under section 7(3) of the West Bengal Premises Tenancy Act, my lord. Why, my lord? Because, my lord, if the date of service of the summons is construed as the learned judge has taken up, then my appearance will be not within the 30 days of the date of service of the summons. And hence my defense will be struck off. Now, what has happened, my lord? The learned judge has specifically said that the service of the summons has been effected. It is based on the presumption under section 27 of the General Clauses Act. Now, my lord, this presumption under General Clauses Act arises only if there is compliance of Order 5, Rule 9, Order 5, Rule 9A, Order 5, Rule 7.
If the summons is duly served,
not served, man. Not served. There's a belief report is there. Belief report says that it was never served on me. There is an infraction in the belief report in as much as the fact, my lord, there was no identifier. My lord knows very well, my lord, the provisions of Order 5, Rule 17, which is a sine qua non, my lord, for the belief to come to a specific finding that he has in fact served the summons. He has to, my lord, there has to be an identifier, my lord, of the premises. And, my lord, the belief has to give on oath before the learned trial court that there has been in fact a service, my lord. Nothing is there, my lord. By way of a supplementary affidavit, my lord, I have disclosed the belief.
How did you appear before the court?
Well, I came to know from the other tenants that the landlord is taking steps against them. And I apprehended that steps might have been taken against me also. That is when I sought information from the learned court below. I received from the information slip.
Information.
Yes, my lord.
For the
Everything.
court to annex that information.
Yes, everything is there. Yes, my lord. Everything is there on record, my lord. Just summing up the points for lordship's convenience. Now, I have disclosed that document, my lord, the information slip. Thereafter, my lord, from the time I have received the information, I have appeared on the second date. Thereafter, I have taken out section 7.1 and section 7.2 application. My apprehension is that, my lord, since the time I have appeared, prior thereto, the court has passed an order specifically stating that there has been due service of summons on me. My lord, number one, my lord, then when the court is acting on the basis of a presumption, when the other side, that is the plaintiff, has not been able to demonstrate that yes, there has been due service of summons, my lord, there has to be.
See, was the matter fixed for ex parte?
No, my lord.
Initial stage. Thereafter, you came.
No,
applied for recalling.
No, my lord. My lord, may kindly have a look. My lord, the impugned order. My lord, before my lord looks into the impugned order, kindly, my lord.
Order number 3.
Order number, no, my lord. The impugned order is order number 14, which lordship.
Order number 3, that is what I think it is relied upon.
Yes, that's important, my lord. May I place the order? My lord, this is where the learned judge comes to a specific finding that the summons have been served. And this is what pinches me, my lord. Because if this date be construed as the date of service of the summons, then my defense will be struck off under 7.3. Now, there is a dereliction of duty on the part of the learned court below, my lord. The learned court below ought to have satisfied itself on the basis of the provisions of Order 5, Rule 9, Rule 9A, Order 5, Rule 17 and 19, my lord. That, yes, in fact, there has been service of summons, nothing done. Coupled with the fact, my lord, that the bailiff has himself stated in the report that neither the defendant nor his agent was present. And there was no identifier that lordship will find at page 10 of the supplementary affidavit. May I place the order number 3?
Decisions are to be considered also. The decisions of the Honorable Supreme Court, which was relied by the learned judge.
Yes, ma'am. May I place order number 3 first?
Yes, order number 3.
Yes, ma'am. Today is fixed for SRAD and appearance. Plaintiff files Hajira along with postal track report with original postal registration receipt affixed on it. On call, plaintiff is found present through learned advocate. Heard learned advocate for the plaintiff who prayed for acceptance of service. Peruse the case record, consider. It appears from the bailiff report. Dated 2nd August 2023, the door of the defendant was found closed. Kindly marks the word closed, under lock and key, and none could give any proper information about the defendant. As such, the bailiff affixed a copy of the summons on the front door of the defendant's room. So far, postal report is concerned. One postal envelope came back with remarks, door locked and finally unclaimed. Perusal of the postal envelope shows that it was sent to the correct address of the defendant. Now let me go through the provisions of General Clauses Act 1897. Section 27 of the General Clauses Act provides where section 27 is reproduced herein under, where any central act or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression service or either of the expression give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be affected by properly addressing, preparing and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in the ordinary course of post. It is also the observation of the Honorable Supreme Court as reported in 2021 4 Indian Civil Cases 368 Supreme Court, and wherefrom it reveals that from paragraph 13 it has been observed. The Honorable Supreme Court in the decision reported in 2021 SCC Online SC 828 in an appeal arising out of proceeding under Order 9 Rule 13 of the Code of Civil Procedure, while dealing with an issue regarding validity of service of summons of the suit, has held that when a notice is sent by registered post and is returned with a postal endorsement refused or not available in the house or house locked or shop closed or addressee not in station, due service has to be presumed under the relevant provisions of the General Clauses Act 1897. Here in the present case, the envelope sent to the defendant through post containing summons came back with the postal endorsement, door locked, and finally unclaimed. The postal envelope is also properly addressed, prepared, and sent by registered post, and there is no reason to interpret any different interpretation. Therefore, in light of the aforesaid decision, coupled with the provision of Section 27 of the General Clauses Act, this court finds no hesitation in holding that the plaintiff has duly discharged his duty by intimating the defendant about the institution of the suit against him, and service has been duly effected upon the defendant. This is what pinches us. But in spite of the same, defendant did not bother to appear. However, for the ends of justice, a chance is given to the defendant to contest the suit. Accordingly, fix such and such for appearance. This is where this is where we join issue. Malat knows very well that the presumption under Section 27 of the General Clauses Act is a rebuttable presumption. If we are able to demonstrate that at that point of time, there was no occasion for the defendant to be present at the demise premises, then the presumption goes. In addition thereto, I have to be given an opportunity to cross-examine the bailiff. Nothing given, Now, it has fallen from Lordship as to when I came to know about it. This order, Lordship will find dated 30th August 2023. We have specifically averred in our petition under Section 151 of the Code of Civil Procedure, wherein we have sought recall of this order on the ground that number one, the presumption under Section 27 is a rebuttable presumption, my lord. I ought to have been given an opportunity to rebut this presumption, number one, not given to me. Number two, my lord have seen from this order that that the learned court below has relied heavily on the bailiff's report. My lord will kindly consider page 10 of the supplementary affidavit, which is a part of Lordship's brief. My lord, page 10 is the bailiff's report. Now, relying on this bailiff's report, the learned page 10 of the supplementary affidavit. This bailiff report cannot be, in my humble submit, the basis of the learned court.
Yes, supplementary.
Yes, page 10. Kindly have a look at page 10. This is the bailiff's report in the bailiff's own handwriting. May I place, Madam?
Yes.
On 2nd August 2023, at about 12:30 p.m., I went to serve one copy of the summon for the defendant at 6A Clive Road, 5th floor, Kolkata 1. There I found the said defendant room was closed. Kindly mark this word. Was closed under lock and key. On inquiry from some person, he does not identify as to who the person is, at the said place, but none could say anything about the said defendant. There, then served the copy of the then I served the copy of the summons by affixing on the outer door at the said defendant room, at the said defendant room, and also I took a photocopy at the photograph of the affixed summons at the front door. Photocopy attached with service report, including copy of the plain. Witness was not available. This is where I join issue, my lord. Order 5, Rule 17 specifically states that there has to be an identifier. If there is no identifier, my lord, this report goes. And relying upon this report and a presumption which is rebuttable in nature, the learned court below specifically held that the summons was served. This is to my utter detriment, my lord.
So this is order dated?
Order dated 3rd August. Yes, my lord. This is order dated.
Thereafter, what is your application?
My lord, then thereafter, kindly have a look at page 54 onwards. That is my application under Section 151, wherein on the grounds that I have stated in the application, I have sought for recall
That
of the order.
means by the said order, the case was fixed for ex parte hearing.
No, my lord, it was not fixed for
What
ex
was the
parte
order
hearing.
passed?
It, my lord, a chance, my lord, kindly have a look at page 52. Page 52. Huh?
Yes, page 52.
Page 52, last portion. However, for the ends of justice, a chance is given to the defendant to contest the suit. Accordingly fixed 30th November 2023 for appearance of the defendants as a last chance or else ex parte. I appeared on 28th of November 2023.
28th. No, is there any observation regarding this? This your defense is struck out or not?
No, my lord. There is no observation. I've taken out application under section 7172. Those two applications are pending. It is.
Question is, you see, you have been given the last chance to appear. In
Yes,
default, it will be hard ex parte.
Yes, ma'am.
Okay.
Yes.
That was the observation.
Yes, ma'am.
So, fixed appearance of the defendant. So, it is there was a presumption of service.
Yes, ma'am.
Not actual service, but service in the eye of law.
Yes. Presumption of service.
Presumption was there. Now the question is, you applied for recalling of this order. What
yes.
was your application for? Let us see.
My lord, one thing I just want to indicate, Lordship.
Yes.
My lord, my application under 151 starts at page 54. My grievance, specific grievance, Lordship will
Question
find.
is, you are granted an opportunity to appear. Okay.
Yes, my lord. I have
let us see page 54.
My lord, may I just indicate my grievance, my lord? My lord, I've seen the order that I've just now placed. The portion of the order which is to my utter detriment is the last portion of page 52, wherein there is a specific finding to the effect that the summons was duly served on me. My lord knows very well that under the provisions of section 7.2, the entire exercise has to be completed within 30 days from the date of receipt of the summons. The application has to be taken out.
So
now, my
date
lord,
for appearance is fixed.
Yes, date for appearance is fixed. But, my lord.
Anyway, so your grievance is, where is your application?
My lord, my application starts at page 54. My grievance, Lordship will find that.
You appeared on that date.
I appeared. Yes, my lord. I appeared
on 30/11/2023.
Yes, man.
You took out an application under 7.1.
No, my lord. I appeared on 28th of November 2023. 28th of November 2023.
Okay, 28/11/2023.
Yes, my lord.
And thereafter you took out this application.
Yes, my lord. On 30th November 2023, I had filed my applications under section 7.1 and section 7.2. That is within 2 days from the date of my appearance. But what is happening, Lordship has seen.
No, that application is not disposed of.
No, that is not disposed of.
So, what is your grievance in this order?
My grievance is kindly
under challenge.
Yes, my lord. Kindly
because your application is not recalled. So, what is your grievance?
My lord, may kindly have a look at page 59, paragraph 14. That is the sum and substance of my grievance, my lord. That is the only reason why I am before your lordship. And I was before the learned court below with my section 151 application.
59, yes.
Yes, paragraph 14. May I place? The petitioner is highly prejudiced by the part of the aforesaid order. That is the order that I've just placed. That is being order number 3 dated 30th August 2023, wherein it has been held and or observed that within court, the plaintiff has duly discharged his duty by intimating the defendant about the institution of the suit against him, and service have been duly effected upon the defendant. But in spite of the same, defendant did not bother to appear. By way of the instant petition and on the grounds as more fully stated in the following paragraphs, the petitioner seeks recall and or modifications by deletion of the quoted portion of the said order dated 30th August 2023 to the extent of service has been duly effected upon the defendant, in as much as the fact that no summons was served upon the petitioner and the quoted portion of the said order dated 30th August 2023 is based on presumption under section 27 of the General Clauses Act 1897, which is a rebuttable presumption altogether. The quoted portion of the order dated 30th August 2023 is highly prejudicial to the interest of the petitioner to seek the benefits of protection available and are vested in the petitioner by way of the provisions of Section 7 of the West Bengal Premises Tenancy Act 1997. Because, my lord, if this portion of the order stands, then the learned court will presume a date of service of the summons which will be beyond 30 days from the date of my appearance. And therefore, my application under Section 7.1 and 7.2 would become osseous, and my defense altogether will be struck off under 7.3. This is what prejudices me, my lord. And it is only for this limited extent that I have approached the learned court below, seeking recall of the order 30th August 2022, and thereafter we are before your lordship.
So what is thereafter the instant suit?
My lord, now kindly have a look as to why. Kindly have a look at paragraph 18, my lord. We have pleaded the grounds. I am only showing the specific grounds. Paragraph 18 at page 61. The petitioner states that after going through the records, it would appear that the bailiff of the learned court visited the tenanted room of the petitioner on 2nd August 2023 at about 12:30 p.m. when he found that the said room was under lock and key, and as none could give proper information about the petitioner, the bailiff affixed the summons on the front door of the petitioner's room, that is the suit premises. It would be pertinent to mention in this context that the said bailiff, while affixing the summons on the outer door of the room wherefrom the petitioner carries on business, and while returning the original to the learned court from which it was issued with the report, did not mention the name and address of the person by whom the said room of the petitioner, that is the suit premises, was identified, or in whose presence the copy was affixed, which is the mandatory requirement of such service as per the relevant provisions of the Code of Civil Procedure 1908. Now kindly turns over the page and considers the pleadings at paragraph 20 and 21. May I place one?
Yes.
Paragraph 20. The petitioner carries on business from the suit premises and has his office at the suit premises. The staff of the petitioner, who regularly attends the said office, was unwell during the first week of August 2023, and since the petitioner had to attend to other business commitments during the office hours outside his said office, the said office remained closed for most of the time during the said period. The paragraph 21. The petitioner states that the provisions of Section 27 of the General Clauses Act 1897 is rebuttable. The petitioner has never been imputed with the knowledge of the contents of the notice, which was allegedly returned with the endorsement unclaimed on the purported ground of the suit premises being closed. Furthermore, no intimation could have been left by the postal peon when the door of the suit premises was locked as reported as such. The imputation of the contents of the notice/summons did not occur at all. It can thus be reasonably presumed that the contents of the notice/summons was never imputed on the petitioner when the notice/summons was allegedly returned unclaimed for the purported reason of the door of the suit premises being locked. Kindly turns over the page to paragraph 23, Lordship. Moreover, paragraph 23, madam, I'm placing. Moreover, the bailiff report dated 2nd August 2023 would go to show that the door of the petitioner was found closed under lock and key, and none could give any proper information about the petitioner, and as such, the bailiff purportedly affixed the copy of the summons on the front door of the suit premises. The bailiff, while purportedly affixing the summons on the outer door of the suit premises wherefrom the petitioner carries on business, and while returning the original to the learned court from which it was issued with the report, did not mention the name and address of the person by whom the said room of the petitioner was identified, or in whose presence the copy was affixed, which is the requirement of such service as per the provisions of the Code of Civil Procedure 1908. Thus, no presumption of service of such summons can be drawn from the purported bailiff report dated 2nd August 2023, and no service of summons of the suit can be presumed by affixation on the petitioner as claimed in the said order dated 30th August 2023. And now kindly turns over the page to paragraph 25. The petitioner states, Manu has found it?
Yes.
The petitioner states and submits that the petitioner has no knowledge about the instant suit until 20th November 2023, when he derived the knowledge from the information slip filed on his behalf before the department of this learned court, and as such, he entered his appearance in the suit on 28th November 2023 and filed an application for direction on the plaintiff to supply the copy of the plaint on the petitioner, and the learned advocate for the plaintiff supplied a true copy of the plaint so filed in the instant suit on the learned advocate for the petitioner on 20th November 2023. This itself proves that there was no service of summons, because my lord knows very well that a summons is always accompanied by the plaint. Now, if indeed there was service of summons on the plaintiff, then I ask this question to myself: what was the occasion for the plaintiff to again serve a copy of the plaint upon a request being so made by the plaintiff's by the defendant's advocate? This specifically shows this fact itself has been admitted by them in the reply to my section 151 application. 7.1 and 7.2 application. This is where I join issue. That is, had this summons been served upon the defendant, then plaint automatically was served upon the defendant, and this was done after the order dated 30th August 2023. Now, what was the occasion for the defendant? They were very well aware that there has been no service of summons on the defendant. Coupled with the fact, my lord, there is also statutory dereliction of duty on the part of the learned court below.
That means an application was filed.
Now, kindly have a look at
direction on the plaintiff to supply the copy of the plaint.
Yes, my lord. This application was filed. This application, lordship will.
When did you file that? 28th itself.
28th November 2023. 20th November, 20 November, we have entered appearance. We have come to know after having received information from the department, wherein we had deposited the information slip. And then on 28th November 2023, my lord, we have entered appearance and we have asked for a copy of the plaint. And on that means, my lord, if we go by the conduct of the defendant itself, then on 20th November 2023 is the first date on which the defendant appears before the learned court below. And within 2 days thereof, on 30th November, section 7.1 and 7.2 application has been filed. But, my lord, if we go by the order dated 30th August 2023, then service of summons has taken place.
So this application was decided, 151 application.
Yes, ma'am. Now, kindly have a look at page 63. My lord will find the prayers. It is in the above circumstances, your honor would be.
Page 63.
65.
65. Yes.
In the above circumstances, your honor would be graciously pleased to recall and or modify the part of the said order, order number 3 dated 30th August 2023, wherein the learned court has held and or observed the plaintiff has duly discharged his duty by intimating the defendant about the institution of the suit against such and such. We have sought for recall of the order. And my lord will find at page 23 of lordship's brief.
23 of this petition.
Yes, my lord, of this petition. The application whereby the defendant have called upon the plaintiff, or rather requested the plaintiff to supply the defendant with a copy of the plaint. Page 23, the application starts. My lord, at paragraph 2 is important, my lord, because it has fallen from lordship as to.
So was this petition allowed?
My lord, they had served us a copy of the plaint.
No, during this petition.
Yes, my lord.
Filed on 28/11.
Yes, my lord. Pursuant
so, no, any order was passed or not on this petition?
No, my lord, no order was passed on this. They had served us with a copy of the.
They have admitted this in their reply to the 7172.
They have admitted this in their reply to section 7.1 and 7.2 application.
That they have served a copy.
Supplementary copy.
This is a part of the supplementary affidavit. I will just indicate.
Page 5 of the
Page 5 of the supplementary affidavit, lordship.
Paragraph 7.
Paragraph 7. With reference to the, may I please?
5 of your supplementary
Yes, ma'am.
affidavit.
That is a part of the reply. Reply to our section 7.1 notice, section 7.1 application. It starts at page 4 of my supplementary affidavit. Page 4. Page 4 is the written objection. Lordship has kindly looks at the caption, written objection against the application under section 7.1 of the West Bengal Premises Tenancy Act filed by the defendant. The humble petition of objection on behalf of the plaintiff. Now kindly turns over the page to paragraph page 5, paragraph 7. May I place paragraph 7, ma'am? May I place paragraph 7?
Yes.
With reference to the statements and or allegations contained in paragraph 2 of the said application are false and denied. It is denied that the defendant entered his appearance in such and such. Well, now kindly comes denied that the defendant entered his appearance in the above suit through learned advocate on 28 November 2023 and made an application by filing a put-up application on 28 November 2022 before the learned court for direction on the plaintiff to supply a copy of the plaint in the above suit. When the learned advocate for the plaintiff supplied a true copy of the plaint in the above suit on the learned advocate for the defendant on 28 November 2023. Now, my lord, see, my lord, they have themselves, and I've also stated specifically.
A copy of that, 2 copies also annexed to the
Unta.
That is also annexed.
My lord, the true copy of the plain, Bolji. In page 29. Page 29. My lord, may kindly have a look at page 29. That is the true copy of the plaint that was served. Page 29. We'll find at the right-hand side corner.
Page 29.
Yes, ma'am. Page 29 of the main brief, Lordship. Page 29, right-hand side corner.
Yes.
Right-hand side corner, Lordship will find true copy signed by the learned advocate, and kindly have a look at the date, 28 November 2023. Lordship has found it.
Yes, yes.
And so there is no dispute, Lordship. This additionally supports my contention that no summons was served. And in addition thereto, my lord, there has been complete statutory dereliction of duty on the part of the
That application became infructuous when
that
they served you the.
yes, madam, they have served us with a copy of the plaint. The point that I want to make
now your application under section 151 was decided.
Madam, now
so that order is under challenge.
Yes, madam, that order is under
challenge. Let us see that order.
Yes, madam. Lordship will find the impugned order at the last page, madam. It is unpaginated. May I place the impugned order?
Order number 14.
Order number 14, madam. It's dated 20th November 2024.
Yes.
May I place, madam? Today is fixed for hearing of the petition filed by the defendant on 14th May 2024. Both sides filed hajira through the learned advocate. No written objection filed by the plaintiff to the above application. Heard both sides, perused petition and other materials on record considered. It appears that the defendant has filed the present petition for recall of the order number 3 dated 30th August 2023, passed by the learned Chief Justice Presidency Small Causes Court, Calcutta, in the instant suit. He submitted that the learned court was pleased to observe that the plaintiff has duly discharged his duty by intimating the defendant about the institution of the suit against him, and service have been duly effected upon the defendant, but in spite of the same, defendant did not bother to appear, close quotes, in the impugned order. The defendant submits that no summons was served upon him as alleged by the defendant, neither had he any intimation of the suit. Rather, the defendant on his own entered appearance in the present suit upon seeking information regarding the suit, as many suits were being instituted against the co-tenants. On his appearance on 28 November 2023, the plaintiff served the copy of the plain to the defendant on his prayer. This is an admitted position recorded in the impugned order itself. His allegation is that the bailiff, while purportedly affixing the summons on the outer door of the suit premises, wherefrom the petitioner carries on business, and while returning the original to the learned court from which it was issued with the report, did not mention the name and address of the person by whom the said room of the petitioner was identified, or in whose presence the copy was affixed, which is the requirement of such service as per the provisions of the Code of Civil Procedure 1908. Thus, no presumption of service of such summons can be drawn from the purported bailiff report dated 2nd August 2023, and no service of summons of the suit can be presumed by affixation on the petitioner as claimed in the said order dated 30th August 2023. The petitioner also states that the presumption of the due service of the notice summons based on Section 27 of the General Clauses Act 1897 on the alleged ground of the notice summons having been returned unclaimed for the reasons of the door being locked cannot be held to be legal. The defendant, in support of his contention, has referred to some judgments as well, which mostly concerns the jurisdiction of the court to set aside the order passed by the same court. He further referred to Section 151 of the CPC, which provides that save as otherwise provided, where the business of any court is transferred to any other court, the court to which the business is so transferred shall have the same power and shall perform the same duties as those respectively conferred and imposed by or under this code upon the court from which the business was so transferred. The plaintiff did not file any written objection. He objected such prayer of the defendant and submitted that where this court can act as the revisional court against its own order. This is the only point that they have raised. He further submitted that this petition has been filed by the defendant with a malafide intention so that his defense as a tenant is not struck off by limitation. Upon perusal of the record, I find that vide order number 3 dated 30th August 2023, the learned Chief Judge, Presidency Small Causes Court, Calcutta, has been pleased to hold that the plaintiff has discharged his duty by intimating the defendant about the institution of the suit against him, and service has been duly effected upon the defendant, but in spite of the same, the defendant did not bother to appear. However, for the ends of justice, a chance is given to the defendant to contest the suit. No doubt that under Section 151 of the CPC, the court has the inherent jurisdiction to recall its order, provided where the court is misled by a party or the court itself commits mistake which prejudices a party. But this is where I join issue. The court has not looked into the law. It has committed a mistake. And in addition thereto, the other side has misled the court also. Or else they would not have served me with a copy of the plaint at a subsequent date. That is also recorded by the learned judge in the earlier portion of the impugned order. Both ways, one of this order cannot stand. The presumption is a rebuttable one. And so far as the bailiff is concerned, my lord, I will show the law, my lord, and my lordship very well knows that there is complete dereliction of duty on the part of the bailiff. There is, and also the court, my lord, because the court, even in the absence of the defendant, ought to have examined the bailiff and ought to have satisfied about this service of the summons by affixation from the bailiff itself. Nothing done. Not even an affidavit called from the bailiff lordship. And the court comes to a conclusive finding that yes, summons have been served without taking into consideration the great implications to follow. I will be rendered remediless, lordship. My defense will be struck off. This one-liner from the learned court below disentitles me of a defense to which I am otherwise entitled to, or rather a protection to which I am otherwise entitled to under Section 7 of the West Bengal Premises Tenancy Act. I am completely denuded of my right because of this observation. I am not against the entirety of the order. And that is the reason why we have taken out an application under section 151. The learned court below has been gracious enough to give us an opportunity to file written statement. But at the same time, the same order has ensured that our defense is struck off under section 7.3 because on our applications under 7.1 and 7.2 will not be considered. Since they were not filed within 30 days from the date that the learned court deems to be the date of service of the summons, when there was no service of summons. So either way around, my lord, from whatever angle this impugned order is considered, it should not stand. Now, the learned court had considered all the aspects, passed the order dated 30th August 2023 on merits, and there has neither been a mistake nor the court was misled by the plaintiff in passing such order. This order should not stand, my lord, in my humble submission.
So the question is, the affidavit was considered.
No, my lord, there was no affidavit.
From the other side, your application was contested or simply oral objection?
Oral objection.
Simple oral objection.
Kindly have a look at the first line of the second page of the impugned order. The plaintiff did not file any written objection.
So your contention is this observation should be expunged.
Only that is my limited contention. That the observation, so far as service of the summons is concerned, it should be obliterated from the order itself. Because it denudes me of the right to which I am otherwise entitled to under the West Bengal Premises Tenancy Act by dint of being a tenant. Section 7 bestows me with certain rights. I have defense. Without being subjectively satisfied about the service of the summons and without complying with the mandatory provisions of law, the learned court below in hot haste has held that yes, there has been due service of summons on me. The bailiff, lordship, I have shown, I have demonstrated from the bailiff report, himself admit that there was no identifier, there was no witness. And it is only on the basis of this report that the learned court below passes such a scathing remark, which has huge implications on my defense, or other my defense will be struck off. This is my limited grievance, and this is why I have approached the learned court below, and that too only to that limited extent.
Because you see, so far your opportunity to contest the suit, that is there.
That is there, but my defense will be struck off, my lord.
Whether your defense...
My hands have been cut off by the observation. But only that is my grievance. But if that observation goes, I am ready and willing to contest the suit. I am also in a position to file the written statement here. Oh, we have already filed a written statement, lordship.
Only thing is your 7.1 and 7.2 is pending for disposal.
That is pending for disposal. I have already filed my written statement, which is a part of the record. But in the event that this observation stays, and my lordship has seen that that is their intention to invoke the provisions of section 7.3 and my defense be struck off without any sort of designation of duty on my part. I have appeared before the court on 20th November. I have shown that is on the 7th day I have entered appearance from the time of knowledge, and on the very second day from entering appearance, I've taken the steps by filing section 7.1 and 7.2.
The question is, the order was passed on the order granting you liberty to appear on 30/11. That was passed when? 30th of August.
Yes, madam. It was passed on 30th of August. I was not aware of this order itself. I have come to know about the order on 20th November. By that time, 30 days have elapsed. As soon as and the section is also very specific, that it is also from the date of the knowledge. I have come to know about the filing of the suit on 20th. I have annexed the information slip, and on 28th, I have appeared. And on 30th, I have taken out these applications. So within 2 days from the date of my appearance, and within 10 days from the date of my coming into knowledge of the institution of the suit, So even though the learned court below has allowed me to file my written statement, but my hands are cut off.
But 7.1 and 7.2 written objection is filed.
Yes, my lord, I've demonstrated my lord.
7.1 and 7.2.
Yes, my lord. 7.1, 7.2.
That in that application, this point is taken regarding service of summons.
Yes, my lord. They have said that I have shown you, my lord, the relevant paragraph.
That is page
4 of my supplementary affidavit.
Page 4.
Lordship, I have annexed the written objection to section 7.1. They have denied that we have not received the summons. And that amounts to.
No, regarding limitation, was that point taken? That limitation?
Yes, ma'am. That
Yes.
point has been taken.
Which page?
Ma'am, I am indicating. Ma'am, the written objection is at page 4 of my supplementary affidavit, annexure 1. And my lord, the limitation point, my lord, I'm just indicating.
Page 20, please.
The limitation of deposit.
Paragraph 20, page 7, lordship. Page 7, paragraph 20. They have taken the point of limitation. In fact, they have urged that before the learned court below itself, while my section 151 application was being decided. May I place paragraph 20? My lord, I found that your petitioner states that the said application is hopelessly barred by the laws of limitation, as the summons was served upon the defendant on 2nd August 2023, and the summons which was sent to the defendant through post, which has been returned back with postal endorsement door locked, learned chief judge was pleased to accept the service of the summons with a reasoned order, and long after acceptance of service of the summons, the defendant has filed under section 7.1 and 7.2 after obtaining an information slip from the learned court, knowing fully well that the summons have already been served upon the defendant and the application under 7.1, 7.2 long after a month from the date of service of the summons. So the application under is not maintainable and liable to be rejected. They have taken this down.
That is the point of limitation.
Yes, they have taken the point of limitation.
So anyway, continue on the next day, or you have completed?
No, my lord, I show the provisions of law, my lord.
No, and those decisions also.
Oh, my, I shall.
Decisions relied upon.
My lord, prior that, my lord, I do not think those decisions will take us a mile, because my endeavor before your lordship is only to demonstrate that there has been a legal infraction, and which I hopefully will be able to demonstrate by the provisions, statutory provision itself. Because what the learned judge has done, my lord, there is complete dereliction of duty on his part, which flows from Order 5, Rule 9, 9A, Order 5, Rule 17 and 19, lordship. I'll place those provisions. Those needs to be placed. My lord, lordship.
Record an order.
Okay.
Learned advocate for
My lord,
the
extends the interim order in the meantime.
petitioner submits. Learned advocates for the parties are present. Learned advocate for the petitioner submits but could not conclude his submissions. Let this matter appear on. So when can you continue? Next week?
Next Friday.
Let this matter appear on 5/12/2025 for further hearing.
The
further hearing of this application.
The interim order be extended. It's expiring.
Interim order granted earlier stands extended till 19/12/2025 or till further orders, whichever is earlier.
Your lordship, today your appellate matters will not be taken up any further.
Yes, yes.
And item 20, I have got an attachment order from the in execution case. Item 20, today's list, your lordship.
Item 20.
Anytime, if your lordship fixes item 20 of today's list, appellate side, your lordship. Attachment order is there, your lordship, from the learned lower court. The Monday.
Take it up at Monday.
Monday, it's the attachment. The Monday, the bank will deduct the amount. The order is there from the any time, your lordship.
So today itself, we want it to be taken
up. Yes, your lordship. The other side is there.
I'm taking it up at 2 p.m.
Yes, your lordship. No problem. Deeply obliged, your lordship.
নামটা একটু নেব।
হ্যাঁ, ওটা সোমবারে কি 2 মিনিট? হ্যাঁ, তো ডিপার্টমেন্ট তাহলে ফাইল তো যায় না মিডিয়েটরের কাছে। চেয়ে পাঠান ডিপার্টমেন্ট, হ্যাঁ চেয়ে পাঠান, যেটা 2 মেনশন থাকবে, যে ওটাকে সোমবারে দিয়ে দিন।
Item number 70 and not to
সোমবারে কি কম্বাইন্ড লিস্ট তৈরি হবে? কম্বাইন্ড লিস্টের মধ্যে থাকবে 2 মেনশন।
বিপ্লব দুটো
কম্বিনেশন ডেটলি
এবার মানলো না
There are Passover matters, madam. 12.
Yes, Passover matters come tomorrow. Come on Monday. Passover matter was criminal
But
revision.
that is court number 42, my lord.
Okay, come at 2 p.m.
Deeply obliged.
Well, item number 70, I'm providing not to the for the petitioner, my lord.
Item?
Item number 17, my lord.
Item 17. Okay, I shall see on Monday.
Yes, my lord.
Say no. 7. Yes, your matter will be taken up at 2 p.m.
Well, 18 also not today, man. 18 not today.
Okay. 2 p.m. এ appellate side যেটা fix আছে আর original side ও তো একটা fix আছে. Yes, your matter probably is fixed at 3 p.m.
That is what your lordship was pleased
Yes,
to
yes,
observe,
yes,
but
yes,
it's
because
under,
in pursuant to the discussion,
Yes,
it is fixed at 3 p.m. I'll take it up at 3 p.m. Your matter.
as your lordship will come back.
My matter is fixed at the top.
No,
Yes.
Original side. Yes, this is original. I'm talking about original side.
I'm talking to him, not to you, to the court officer.
The appellate side. Original side.
My matter is original side, 3 p.m. fixed.
Yes, come at 3 p.m.
What at all?
It is not appearing at the top. It is appearing as item number 3.
এটা তো 1 নম্বরে থাকার কথা কন্টিনিউইং পার্ট
Anyway, item number 1 will be taken up at 3 p.m.
ভেরি ওয়েল
So item 2 will not take more than 2 or 3 minutes. So I'll
We
take
can
it up.
wait,
Take up item 3.
because I want to conclude and the lordship has specifically said it will appear at the top. Order indicates that.
My lord, item 2, my lord, lordship had not issued, my lord, item, my lord, issuance of a subpoena, my lord, for production of, my lord, record from the registering authority, my lord.
Yes,
my lord,
yes, yes. Item 2
Yes.
was the direction was issued.
Yes, my lord, we have.
Item 2 এর অর্ডারটা দেখি।
এক second.
Item number 2.
Yes, item
Lord, I appear, my lord, for the RA Calcutta. Lord, your lordship had directed, my lord, production of a record.
Yes.
Just কোন কথা আছে? My lord, Lord, it's 100.
Plaintiff's advocate is here.
Original আমাদেরটা?
ওটাই।
Yes, Mr. Dotto. Yes, the registering authority is represented by Mr. Sinha. So Mr. Sinha will look after this matter.
My lord, I have the records. My lord,
upon the
Yes.
registering
my lord, I've got the records.
Now, if my lord permits, my lord, I will just tender that.
My lord, I have plaintiff number 1.
This,
I want to explain this matter of fabrication of Orpanama, my lord.
Question is, you see,
my lord, my lord, the only difficulty, my lord, is, my lord, as a lordship can see, my lord, the pages are getting, because more than 100 pages are getting.
you better sit with Mr. Dotto and the parties today. Okay.
Yes,
I shall take it up next Friday.
My lord, my
What I was-
submission be recorded, my lord.
What I was
Record your presence.
I just indicate.
Yes.
We would be tendering that document. That's a fragile document. That's why they could not give a certified copy.
So come at 2 p.m. I
No,
shall
they
take it up.
cannot take.
So
Lord,
I will
if-
just
No, come at 2 p.m.
2 p.m.
Yes,
today.
yes, come at 2 p.m. Mr. Sinha, please come at 2 p.m.
I personally may not be there,
Because of
Lord.
this
Mr. Mondal will be there
particular
at 2 o'clock with this.
Because
Lord, my request, Lord, to your lordship, Lord, since, Lord, we cannot, Lord, photocopy it, Lord. Lord, if they could not take pictures, Lord, and if your lordship permits, we'll certify that. Lord,
Yes,
I think
my
that,
my lord,
is-
My lord,
So can you do that by 2 p.m.?
Yes, yes.
no,
My lord,
not by
after-
2 p.m., not by 2 p.m., but Lord, we'll do it not by Monday.
My lord, may I just indicate?
Present to
First,
Dr.
it would be
And your
tender.
lordship needs to not pass an order, Lord, because that's not the normal
Whatever
process.
it is, you sit with Mr. Sinha, okay?
Keep it at 2 p.m. Let me tender it because the registering authority is present today, my lord, with the document. Once I tender it, the officers can take a
Lord, I
photocopy
can't-
it and
Lord,
deal with that, my
Lord,
lord.
I can't not hand
Because-
up the entire book, Lord, because this has several other records.
Yes, it will be kept and the original will be returned.
Yes.
That
the
Kindly keep it.
question is beyond this thing, my lord. Original copy has been copied here.
So,
Where is that original copy?
so Mr. Sinha, you better
Court is
I'm keeping
not
it
in
at-
a position to ascertain why the fabricated original
keeping it at 2
copy
p.m.
has been copied here.
In that case, Lord, lordship, kindly keep it at 1 p.m., Lord, may come back at 1 p.m.
Yeah,
Those two,
yes.
Lord,
My lord, it is not reliable, my lord.
20 minutes time like I will just tender.
Donors have died, keeping it
Okay.
peculiar in hands of.
So you have some difficulty at 2 p.m.
Lord, I have some, Lord, Mr. Mondal will be there, Lord, lordship keeps it, he'll be there with the records.
Kindly,
He'll be there with the-
kindly note that
Please.
exclude.
Please come at 2 p.m.
My lord, entire Calcutta High Court it becomes under.
Yes, call the next matter.
Item number 3.
Yes, correct.
Nobody knows anything.
Didi.
My lord, original
I have called
has
another matter. Please come at 2 p.m. No further
Okay,
submission.
please.
But I was addressing outcome today.
Yes, what is the other, Mr. Mitro and others?
Mr. Mitro was there, I met him.
I'm there virtually, my lord. Kindly allow me to be there virtually. I will give my rejoinder the next day.
Yeah, in the court.
My lord.
Okay, okay.
By Mr.
Let him finish, Miller.
Yes.
I would conclude today.
I have concluded. I may say a few things after he finishes.
Just a minute.
Just for 5 minutes.
Milord, may I, Milord? Lordship has brought...
Just a minute. এখানে দেখুন কি লেখা আছে এই ব্যাপার অনারেবল জাস্টিস আমার কোর্টে আছে কি
কাউকে না বলছি
লেখা আছে কি
ওইগুলো তো না
আরে তুমি বই দেবে সিনিয়র আমি ওই পাশটা বসো আপনারা তো পেছনটা বসো
হ্যাঁ
ওইগুলো
অ্যাডভোকেট তো নেই কেউ কোন ম্যাটারটা
বিটটা দিয়ে আমার বিটটা দিয়ে
এটাতে কি রিপোর্ট এসেছে Yes, a report has come from the registrar in this matter. Let me see.
Relating to our matter, item 3.
Yes. That is CS 280.
Yes.
Yes. A report has come.
Lordship did not call for any report. But anyway, Lordship would kindly look into that. What
18th
report?
September 2025. Certificate from the department as to which defendants have entered appearance and filed written statements. Okay, no written statements have been filed by the defendants till 31/10/2025. This is the position.
Very well. We will proceed on that basis.
Yes.
There is no application for extension of time to file written statement also.
No, I am not on that. I have just sought a report that how many defendants have entered appearance and filed written
Present status, Milord.
Yes, present status.
None of them have filed written statement.
Yes, this is the position. Yes, please.
Milord, on the last day, I placed the plaint, Milord, amended plaint extensively. And I showed you all the paragraphs from the amended plaint, which Lordship has taken note of it, that the plaint discloses a cause of action. The court may say, why are you saying this? Because, my lord, I am an interested party. It's a suit for partition. I also want partition, though I have been impleaded as defendant number 36. Partition of the estate of late Arun Bhutoria. Plaintiff is the widow. Defendant number 36, 37 are the two sons. And the other beneficiary is the mother who has also been impleaded. So if it is
the
partition,
defendant number 1
and 2 are the contesting and they have filed this application.
But defendant number 1 and 2, who are, according to you, are the shareholders.
Shareholders in respect of some of the companies. But does not
they,
have
they
any
did
right.
not file the written statement.
Did not file, in spite of direction.
They entered appearance, but they did not file written statement.
Did not file anything, though that order Lordship might recall of Justice Sen, which records the fact that the averment made in the plaint preeminently shows their existence of joint family property. That observation I had shown to your Lordship. And that has not been challenged, accepted by the parties, and that order was passed on an application for amendment of the plaint. So plaint was amended. Matter could have ended there because no appeal has been preferred. However, after a period of 12 years from the date of filing of the suit, this application has been filed, which is a demurrer application.
That is, plaintiff has sought for partition along of the shares for herself and defendant number.
And whoever, defendant number 36, 37, I
Defendant
represent
number
36.
37.
So, and the mother 35. So each one will get 1/4 if the properties are partitioned.
637 and 36, 37 has entered appearance.
Did
but
not file.
written
That Millard, the record will depict Millard, the position. So the beneficiary of the suit for partition will be the legal heirs. 1 and 2 are the shareholders, and how one was inducted, I have shown you from the pleading. The cause of action, I have shown you how it has been pleaded. And most importantly, the averments made in the plaint are to be taken as true and correct. I have shown you, Lordship has taken note of it. I will again show you, Millard, and I will indicate in my notes. Now, Millard kindly takes up their application. Application to their application. Kindly have a look at the master summons, what they have prayed in this application. Kindly takes up their master summons first. Master summons, prayer.
Yes.
Kindly have a look at the master summons, what they have prayed. Prayer A. Plaint filed, Lordship has got it?
Yes.
I will show you the prayer and the averments made in the application to show the nature of the application and what relief they are asking. And this has to be compared with the plaint.
Defendant number 3 to 34 be rejected.
Right. 1 to 34 be rejected first.
This is, yes,
1 to 34. 1 to 34. And what kindly consider what we have prayed in the amended plaint, partition of 3 to 34 amongst other, because 3 to 34 of the companies which are created out of the fund of late Arun Kumar Bhutoria. So they are saying all be go, all be removed, rejected, plain be rejected as against 1 to 34. So what will
sought from 3 to 34.
3 to 34 amongst other all assets. And you have to read and consider the plaint only. So if this goes, what remains? What actually they want, Millard, Lordship would know from the averment and the averment made in the application. All I will show, and I will try to, Millard, show how frivolous their stand is. Second B, CS number B, alternative prayer, of course, rejection, alternatively suit be dismissed as against 1 to 34. 1 to 34 again. So 3 to 34, Lordship has taken note of it. Pleadings I have shown on the last day. Why the plaintiff is asking for partition? Joint family fund, joint family corpus fund, all came from that particular gentleman who passed away. Then alternatively, that's very interesting, the names of the plaintiffs 1 to 34 be deleted.
Defendants.
Yes, all defendants. 1 to 34 be deleted from the array of parties, and all pleadings, prayers concerning affecting these defendants be expunged under Order 6, Rule 16 of the Code of Civil Procedure. Now kindly have a look at Order 6, Rule 17. When it can be done? Vexatious, frivolous. These are the principal grounds, and abuse of process of court. Does it appear from the plaint, Millard? Demerer application prima facie, Lordship will be deciding. Kindly consider. Order 6, Rule 16. Striking out of pleadings. This is what they have prayed. The court may at any stage of the proceedings order to be struck out or amended the matter in the pleading, which may be unnecessary, scandalous, frivolous, or vexatious. What I was saying. Does it appear from the plaint? When the plaint has to be taken as true and correct? Did the plaintiff not plead about these facts? Yes, they did. Now B, which may tend to prejudice, embarrass, or delay the fair trial of the suit. Does it indicate from the plaint? Where is the scope of striking off the pleadings? When the court will proceed, the averments made in the plaint are true and correct, and the nature of the application is demurrer application. You are asking the court to probe or to investigate into the pleadings. Permissible at this stage? No. Then matter ends there with greatest of respect. Then, which is otherwise an abuse of process of court, what I told your lordship, under these grounds.
That is there. That is inherent power is always
correct. Now you have to consider and read the plaint. Lordship has read the plaint.
Just like a partition suit plaint.
Absolutely.
Yes.
Absolutely. Declaration converted to a partition
That
suit.
is the question, you see. Their ground is whether this suit is barred by law.
Yes.
From the plaint itself.
Alternatively, first I showed you, alternatively, this alternative prayer grows straightway. Nothing is scandalous, frivolous, vexatious, and there is no abuse of process of law.
Okay, the court has to confine itself to prayer A and B.
And partial rejection is not permissible.
Yes.
Now the point was taken about 430 bar. Let me not cite a judgment on this.
Yes.
আমার তো নোটটা না হলে মুশকিল হয়ে যাবে সব আমার লেখা আছে ভাই কোথায় আছে আমার তপন আছে জাস্ট গিভ মি আ মিনিটস টাইম দাদা একটু আমাকে একটু এক সেকেন্ড But kindly have a look at this judgment. I am handing over and relevant paragraphs. Lordship would kindly take note of it. Then I will. I think you have also probably relied about Santosh Kumar Agarwala, Sajjan Kumar Agarwala. You can take note of it. I will give you a copy. Because right now I only have one. The relevant paragraphs, Miller. Right, just give me a minute's time. না আরো প্যারাগ্রাফ আছে আমাকে একটু দেখতে দাও দাদা এক সেকেন্ড My lord, there, my lord, the point arose. Order 7, Rule 11 application was filed. Before the division bench, point arose whether the suit is barred by Benami Transaction Prohibition Act and also whether it's barred by Section 430 of the Companies Act. Because that particular...
Yes, which is the relevant paragraph?
Yes, the paragraphs, my lord, I would straightway come to, my lord. Paragraph 38 onwards, Lordship would kindly consider. Facts I am not placing. না আমার ওইটা ওখানে বসে গেছে আমার তো জাজমেন্টই খুঁজে পাচ্ছি না ও জানেই আমার কপিতে পুরো নোট করা ছিল তো মামলা মুশকিল কি করে The bar karo to. Lordship, may I, my lord, please sit, my lord. Bar karo to, my lord. We find from the reliefs, may I, my lord. We find from the relief sought in the plaint that the argument as to the NCLT having jurisdiction applies to only certain consequential reliefs sought in the suit in respect of the alleged mismanagement of the funds of the defendant companies. If the said reliefs are held to be barred at the final hearing of the suit, the primary reliefs of declaration and partition cannot be held to fall within the domain of NCLT jurisdiction. There also the suit was for declaration and partition. As held in so and so supra and supra, disputed questions to
প্যারা লিখেছিলেন নোটে
কোথায় আছে নোটটা দাও না না আমাকে দরকার কোথা থেকে পাচ্ছ এই নোটটা থেকে বার করে দাও as held in Dwarka Prasad Agarwal by by LRS Supra, the jurisdiction of the civil court is not completely ousted by the Companies Act 1956. The plinth of the plaint case in inheritance of the shareholding and assets of the defendant companies by the plaintiffs. What has been claimed in the suit is, kindly take note of this, declaration of their title in the assets, which are the subject matter of the suit vis-a-vis the companies involved, on the strength of shareholding and cross shareholdings, which prima facie indicate that it is a joint family.
That is why we have to see whether this fact is applicable.
Squarely applies because of the averments. Right now, you can't go and look into the documents.
Right.
Contention and rival contentions cannot be gone into at this stage. So what the court will see in a demurrer application, the averments, which I have shown you. Categorical averment has been made that it comes out of the fund of late Arun Kumar Bhutoria. The companies were created. Substantial stake he had. All came from AK group of companies. So if that be so, how this will be decided at this stage, or how it can be held, my lord, that the suit is not maintainable?
The 430 is applicable in this.
It does not, the judgment says. I will tell you, lordship, why.
430 is not applicable.
Not at all. Not at all. I will show you. Let me, my lord, continue, my lord. What has been claimed in a suit for declaration of their title, I have shown you, which kindly have a look at paragraph 39, which prima facie indicate that it is the joint family, I stop there, comprised of successors of late Shukhendu Prasad, who have pervasive control over the companies. The directorship of the companies are primarily held by the family members of so-and-so. Thus, going by the averments made in the plain, kindly take note of thus going by the averments made in the plain, the companies are joint family companies to which concept of quasi-partnership is squarely applicable. Since allegations of mismanagement have been made, which are consequential reliefs of declaration and partition sought in the suit, the principle laid down in so-and-so is squarely applicable as per the plaint case. It is only the plaint case which is to be looked into.
Yes, this is well settled.
Now, what the court held, kindly see. The plinth of the plaint case is that entire assets of the defendants, be them juristic, corporate entities, or biological persons, emanate from the joint family nucleus of the family, then so and so. Thereafter, the plaint goes on to plead that such joint family nucleus was used for the purchase of assets and to gain control over the family companies, which all started from the sole proprietorship of late Sukhdev Prasad. Here, just change the name, Arun Kumar Bhutoria. Only difference, significant difference, is the change of name. The rest remains the same if you read the amended plaint and the averments. Then, again, at least 3 of the joint assets, which are the subject matter of the suit, are immovable properties not belonging to any of the companies, as such were rightly brought within the hodgepodge of the partition suit. It is well settled that there cannot be any partial rejection as held in so-and-so. A case was referred to 2018, 11 Supreme Court cases, 780. In any event, if the civil court is of the opinion at the final hearing of the suit, upon taking evidence and hearing arguments of the parties, that a part of the claims do not fall within its domain, but are to be decided by the NCLT, it is always open for the court to relegate the parties for such reliefs to the appropriate forum, which, while granting decrees in respect of the primary reliefs. Importantly, the reliefs pertaining to the management of the affairs of the companies are only consequential to the primary reliefs of declaration of the shares of the parties in respect of the subject matter of the suit, flowing from the claim that those can be traced back to the joint family nucleus and partition partition of such joint assets. The said primary reliefs cannot be granted by the NCLT, but come squarely within the purview of the civil court. Even as per the judgment cited by the respondents, if the disputes pertain to questions of title and squarely fall within the domain of the civil court, the exclusion of the jurisdiction of the civil court under section 9 of CPC is not readily inferred. Thus, if at all, the plaint would have to be rejected or returned partially. Such plea being not permissible in law, the impugned order returning the plaint as a whole is bad on such count at all. Then jurisdiction of the NCLT as well.
Anyway, regarding the reliefs,
Kindly permit me to place it. It's not barred.
Yes.
The law is well settled. It's not barred. There is a difference which comes under section 430. That is basically operation and mismanagement. If you question relating to the operation and mismanagement and whether the public interest is involved or not, that is one part.
But regarding declaration of the shares of the parties,
civil suit, my lord, it's a partition. It's a partition. Can't be decided.
For partition and administration.
Absolutely. What is the primary relief that has been claimed? That is important. Civil court has that. The company NCLT under 430, that bar will not apply. You can't go there.
That means administration of the property, not affairs of the company.
Correct. Absolutely.
That is the...
Absolutely. For affairs, you can go there.
But for properties, only assets.
Yes. You can't ask that relief there. I'm grateful then. A careful perusal of the reliefs claimed in the plaint against the defendant companies shows that they are ancillary reliefs flowing from the primary reliefs of the declaration partition. Consequential reliefs cannot be determinant of the jurisdiction of the court. Importantly, the NCLT does not have jurisdiction under sections 241 or 242 of the companies of the 2013 Act to decide the title of parties either to shares or to the assets of the company. What Lordship has said, that is exactly.
This property, that is the property of X company limited, is the property of the plaintiff and defendants or from the joint shares or from
Lordship.
That has to be adjudicated by the civil court.
Absolutely.
If whether it is a company property or from the funds of
mismanagement
of plaintiff defendant,
that's a different thing altogether.
Or whether it is a Benami, whatever it is, it has to be decided by the civil court.
Absolutely.
Regarding whose.
Even Benami also.
Yes.
Even this has been discussed. I will show you.
Decided by the civil court.
Yes, absolutely. Suppose, my lord, I purchase a property. I tell your lordship, giving an example. I purchase a property in the name of Mr. Siddhartha Mitro. But actually, I do it for the benefit of some others, like Vivek Basu and other, Ms. Ipshita Ghosh. Now, when the bar is to be lifted, there is a bar. There is a bar under Benami Transaction Act, Prohibition Act, 1988, which says there is an exception. If you can show it that belongs to the joint family property and that is benefit for that particular persons, then that bar goes. It's for civil court will decide it.
Right.
There is an exception to that provision. All not barred. Kindly have a look at the plaintiffs do not claim merely in the capacity of shareholders, but seek a declaration of joint ownership. Absolutely identical. Kindly seize this. On the strength of title derived from the fact that the entire assets of the companies involved were purchased from the joint family nucleus of the family and can be sourced back to such nucleus. Exactly this is what has been pleaded in the plaint. Then, thus the reliefs do not confine themselves to the mismanagement of the affairs of the company standing on an independent footing. So that's not the case made out in the plaint. The plaintiff's claim over the entire subject matter of the suit, including the assets of the company and the shares of the companies, apart from certain other immovable properties which do not belong to the companies. Such claim of title by inheritance to the shareholding and other assets is entirely beyond the jurisdiction of the NCLT to adjudicate upon sections 241 and 242 of the Companies Act 2013. Possibly it talks about mismanagement and operation, 397 previously. So the 430 bar does not apply at all. Next, the bar in section 430 of the 2013 Act is only applicable in respect of the reliefs which come within the exclusive jurisdiction of the NCLT and cannot be stretched beyond the same. And what is the exclusive jurisdiction of the NCLT? That has been stated in paragraph 44, affairs of the company. Reliefs which can be granted exclusively by the civil court thus cannot be covered by section 430 of the 2013. Hence, the NCLT does not have jurisdiction to the primary reliefs claims in the suit. Court has categorically held. Then, concept of quasi-partnership, I am not on that. Now, Benami, kindly come to paragraph 49. All has been dealt with categorically. Although, Lordship has got it, paragraph 49. Although it is pleaded by the appellant that Benami is a new ground, argued for the first time in appeal, since the court can suo motu reject the plaint under Order 7, Rule 11 of the court, or return the plaint under Order 7, Rule 10 thereof, and the argument of Benami has been made on the basis of averments in the plaint itself, and no new facts are required to be decided, we are of the opinion that the said ground can be validly argued by the defendant response even for the first time in appeal. Point of law, court said you can argue very well in the appeal. Then, the argument of the plaintiff's appellants that since the latest amendments of the Benami Act came in 2016, 10 years subsequent to the institution of the suit, the same cannot be applied is not acceptable, since as on the date when the application under Order 7, Rule 11 of the Code was filed, the 2016 amendment had already come into force. The relevant juncture for deciding the applicability of the bar incorporated in the Benami Act by 2016 amendment is the date when the decree is passed. Hence, the said defense of the plaintiff is not tenable. So, this amendment part, and after the decree, court held, it can be argued. Then what is the observation? Even considering such angle, from such angle, I was talking about the exception, section 29AB of the Benami Act, in a subclause Roman 1 and Roman 4 thereof, incorporate certain exceptions to the bar of Benami. Kindly take note of it. Subclause 1 contemplates as one of such exception a scenario when the property held by a Karta or a Hindu undivided family HUF. Kindly take note of it. They are governed by Mitakshara school of law. So that concept is there. All dealt with, my lord, in this judgment. If the property is held for the benefit or for the benefit of other members in the family, I was talking about this, my lord, and the consideration for such property has been provided or paid out of the known sources of the HUF. In the present case, the said exception is very much applicable at a glance, since the entire title to the suit properties and the shares of the parties in the suit properties are claimed on the premise of the joint family nucleus, which allegedly forms the basic acquisition of the properties. And that has been pleaded in the amended plaint. I have shown you time and again.
After the amendment of the plaint, this application is taken out.
Yes. Even before amendment, single bench has held preeminently shows existence. However, amendment was made, post-amendment, it should have been put to rest. Prior to amendment, court held there is existence of joint family. After the amendment, obviously. And I've shown you all paragraphs. I will indicate that. And the amendment was not made after the order was made. First division bench, keeping the issue open, single bench proceeded on that basis, said yes, preeminently shows the existence of joint family property, amendment allowed. After 12 years, one fine day, you woke up, file an application. Purpose is suit not to be transferred and suit will not be here. That's the only purpose, what it seems then. In the present case, my lord, the said exception is very much applicable at a glance, since I have placed it on the premise of the joint family nucleus, which allegedly from the acquisition of the properties. Here, the case of joint family nucleus and the fund, how the companies, AK group of companies, defendant number 3 to 34, was incorporated or created, has been specifically pleaded.
Whether that has to be decided at the time of trial or not.
They go, they're out then.
Even if it is a malafide benami, whether that has to
Trial.
be decided
The moment you say,
from the plaint itself, whether it can be decided whether it is a malafide objective.
what you have to see the averments, unless it is absolutely apparent.
And
malafide, vexatious, scandalous, abuse of process of law, delay of trial, Order 6, Rule 16. How can you delete or expunge the pleading? Where is that in the plaint? Where is that? You may have a best of best case for going to trial, not at this stage in a demurrer application. Then 52. Again, under subclause 4, where the names of the lenient ascendants or defendants and the individuals appear as joint owners and the consideration of the property has been provided or paid out of known sources of the individual, it is very much arguable that the exception to the bar is applicable. Kindly take note. So there is an exception. What I was just given an example.
So whether this, that is the question, these exceptions can be shown if the parties are relegated to trial or not.
Absolutely.
That is the question.
Absolutely. At this stage, you can't.
From the plaint itself, whether it is possible for the court to see the malafide of
But
the
with greatest of respect, it's not possible. I've pleaded.
Then it goes.
Absolutely.
Then
Straight way it
application will
goes.
go. If from the plaint, the malafide cannot be determined.
Prove your case that
or the bar under the section 430 cannot be established, then the application will go.
You go to the box, prove your case. You show that the companies were not formed out of the fund of late Arun Kumar Bhutoria, produce the documents. You show that the exception of the Benami Transaction Act does not apply. Actually, there was no such thing under which it can be said the exceptions comes. You prove your case there. Because your written statement, though you have not filed it, even after 12 years, will not even be considered. That's the demurrer application. That's the plaint. Then, such exceptions cannot be ruled out at the threshold. In the preliminary stage, when the court adjudicates on an application, kindly take note of it. The observation, the ratio on an application for rejection or return of the plaint. Such questions are to be decided upon taking detailed evidence. And as such can only be finally adjudicated at the hearing of the suit upon a full-fledged trial, what the Lordship has said. Exactly that has been recorded. Can't be decided right now by any stretch of imagination. Because you are just simply, my Lord, kindly see, at this stage, if you allow, on this pleading, what we will do? You will just throw the plaintiff out. Will not give an opportunity to go and prove his case. Is it that case? All beyond doubt? Certainly not. Then, thus we are of the opinion the bar under Benami Act is, to say the least, an arguable issue and required to be decided upon adjudication of detailed evidence on facts. Here, no occasion arises at this premature stage to return the plaint or reject. Appeal allowed. Order 7, Rule 11 goes, my lord. Finally, I'll kindly see the conclusion.
Yes.
57, FMAT allowed on contest, set aside the impugned order by the trial court, suit dismissed, that order was set aside, then obviously then the suit will be proceeded with. Another judgment, my lord, I will be relying upon.
So this is an unreported judgment.
This one unreported. Division bench, my lord. Maybe it's reported in, I do not know whether it has come out. হ্যাঁ নিশ্চয়ই দেবো একটা কপি আছে একটা কপি দাও আমাকে একটা কপি দাও তো একটাই দেখিছি রে বাবু একটা কপি দাও না ওকে দিয়ে দিস একবার কেস নাম্বারটা ওকে বলেছি রে ওপাল দা 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 লেখ 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 আরে তুই আবার স্যার লেখ Next, 2022, Volume 7, Supreme Court Cases 644. On the first day when I opened my case, Lordship might recall, I placed Order 14, Rule 2. At best, what can happen? 2022, Volume 7, Volume 7, Supreme Court Cases, page, my lord, আমার নোটটা কই একবার দেখি 731 আমার নোটটা আমি করেছি দাদা এত এখানে এই জাজমেন্ট গুলো রেফার করা আছে না, এই প্যারাটাই চাইছি, আমি তো জানি কি করেছি। এটা এখানে কোথায় আছে? 731 বলো।
Yes.
731 না না না, কেউ ওই প্যারাটাই দিতে পারছে না, কি যে লিখছে ভগবানই জানে।
এই প্যারাগুলোই দেওয়া আছে।
দেখছি, এক সেকেন্ড দেখছি, 1 মিনিট দাঁড়া। বলো 2022 ভলিউম 7 সুপ্রিম কোর্ট কেসেস 731।
Yes.
এই যেটা বার করছো না, ওটাই নোটটাই লেখা আছে, তাহলে আমার সুবিধা হতো। তোমরা হোয়াটসঅ্যাপ দেখাও তো, আমার একটু অসুবিধা হয়। আমি ওই নোটটাতে লিখে রেখেছি, জাস্ট ওটা দেখালেই হয়ে যেত। ওই প্যারাটা না দেখিয়ে হোয়াটসঅ্যাপটা দেখাচ্ছ তো, আমার ওইটাই অসুবিধা হচ্ছে শুধু। আমি লিখেছি তো, অবশ্যই লিখেছি, আমি যেটা রিলাই করছি। বার করো, কোথায় আছে একটু কষ্ট করে বার করো। Lordship would kindly have a look at this. I'm handing over the judgment and placing the relevant paragraphs. একবার দিন জজ সাহেবকে। Para 7, Lordship would kindly have a look at this. একটা পেয়ে গেছি, আর অন্য জাজমেন্টের প্যারাগুলো বার করে দাও তো। না, ওখান থেকে বার করে দাও, তাহলেই হবে। Paragraph 7, Lordship would kindly have a look at this. প্যারাটা বার করিয়ে দেবে। Yes. Kindly have a look at paragraph 6. It talks about Order 14, Rule 2.
It was a Calcutta High Court judgment.
Yes, went to Supreme Court, arising out of, no, it's a Madras High Court, I think.
No, probably one.
2000.
Yes, High Court and Calcutta.
Yes, kindly, আমি একটু দেখে নি দাদা, আমাকে একটু আমার মতো সময় দাও একটু, প্লিজ দাও। Kindly come to head note B, Order 7, Rule 11D. That point for Lordship is correct. Point taken whether suit is barred because of barred by law limitation. Mixed question of fact and law. On that premise, Lordship would kindly consider the relevant paragraphs. 7.
Yes.
7.1.
Para 7.
Para 7.
Yes.
Now, so far as the issue whether the suit can be said to be barred by limitation or not at this stage, what is required to be considered is the averment in the plaint. Once in a case where on the face of it, it is seen that the suit is barred by limitation, then and then only a plaint can be rejected under Order 7, Rule 11D on the ground of limitation. Limitation is also a point of law.
Yes.
Benami like Benami and bar under 430. At this stage, what is required to be averment? For the aforesaid purpose, the court has to consider and read the averments in the plaint as a whole. So entire plaint has to be read. What my learned friends did, my lord, reading a particular sentence from a paragraph, trust, I will come to that. It's held in trust, no partition. That, my lord, is not permissible. You have to read the entire paragraph or in the entire plaint. For the aforesaid purpose, the court has to consider and read the averments in the plaint as a whole, as observed and held by the courts in so-and-so. Rejection of a plaint under Order 7, Rule 11D by reading only few lines and passages and ignoring the other relevant parts of the plaint is impermissible. You can't do that. It has to be read as a whole and in its entirety to give a true and proper meaning. One sentence apparently.
Yes, a plaint should be read as a whole.
Absolutely.
One sentence finds that
absolutely
upon reading the averments in the plaint that the suit is barred by under any law, the court has
absolutely only then, and it has to be on the basis of the plaint itself,
yes,
and no
yes,
other way. Then, my lord, a judgment was referred to 7.1. Lordship would kindly see. From the aforesaid decision and even otherwise, Lordship has got it at page 736. I'm sorry.
Yes.
From the aforesaid decision and even otherwise, as held by this court, in a catena of decisions, while considering an application under Order 7, Rule 11 of the CPC, the court has to go through the entire plaint averments and cannot reject the plaint by reading only few lines, passages, and ignoring the other relevant parts of the plaint. Then, 8. In the present case, I'm just skipping over 7.2, my lord, a judgment was referred to. I'm not troubling your lordship again to go on to that. 8. In the present case, while holding the suit as barred by limitation, the High Court has considered only the averments made in paragraph 4 and has not considered the entire plaint averments. Paragraph 9 then. While rejecting a plaint, the High Court has also observed and held that the suit for a declaration simpliciter under Section 53A of the Transfer of Property Act against the original owner would not be maintainable, and for that, reliance is placed upon a decision of this court in so and so. However, it is required to be noted that even the plaintiffs have also prayed for a decree of permanent injunction, claiming to be in possession, and the declaration and permanent injunction as such invoking Section 53A of the Transfer of Property Act. So not only declaration, injunction has also been prayed for, claimed. So there are several reliefs which the plaintiffs have claimed. Then para 10, that is important. When the suit is for decree for permanent injunction and it is averred that the plaintiffs are in possession of the suit property pursuant to the agreement, and thereafter they have developed the land and that they are in continuous possession since more than 12 years, and they are also paying taxes to the corporation, the cause of action can be said to have arisen on the date on which the possession is sought to be disturbed. If that be so, the suit for decree for permanent injunction cannot be said to be barred by law. It is settled proposition of law that plaint cannot be rejected partially. So you can't do that.
Even if one relief is barred,
Absolutely.
the other relief.
It can't be done. There are judgments galore on this. I'm just citing one. CPC type. Now, let's kindly have a look at CPC. Order 14, Rule 2. Though I would submit, Millard, they have no case at all. But even then, I must show you there is a provision. Order 14, Rule 2. Lordship has got it, Millard, Order 14.
Yes, yes.
Rule 2, Millard. It talks about framing of issues. Rule 2, court to pronounce judgment on all issues. 1. Notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions of sub-rule 2, pronounce judgment on all issues. Kindly skip over. 2. Where the issues of both law and of fact arise in the same suit, and the court is of opinion that the case or any part thereof may be disposed of on an issue of law only, it may try the issue first if that issue relates to the jurisdiction of the court. Court has no jurisdiction. A bar to the suit created by any law for the time being in force.
Yes.
711D, barred by law.
So that preliminary issue can be framed in that
At best, if the court thinks that certain documents are to be looked into or a detailed full-fledged trial,
preliminary issue in
make
that
it a preliminary issue at best, at the highest, what you can do. Otherwise, this should be like another issue with, is the suit maintainable or not? Now, kindly also sees Order 7, Rule 7 first. সিধা তো দাঁড়ানো গরম করলে তো আরো গন্ডগোল হয়ে যাবে
Order 7, Rule 11.
Order 7, Rule 7.
Rule 7.
Order 7, Rules 11. Rule 7. Aste, dada, aste.
Yes.
Reliefs to be specifically pleaded, specifically stated. These provisions Lordship may consider. Every plaint, Lordship has got it?
Yes.
Every plaint shall state specifically the relief which the plaintiff claims either simply or in the alternative. So plaintiff has option. And it shall not be necessary to ask for general or other relief which may always be given as the court may think just to the same extent as if it had been asked for. And the same rule shall apply to any relief claimed by the defendant in his written statement.
Anyway, this is not applicable because
May not be,
there is no dispute.
but
with
either
regard
in
to
the simple or in alternative, I can do it.
And there are
Reliefs.
decisions court may mold the relief also.
Always. Relief founded on separate grounds. This Lordship may consider.
Yes.
Whether the plaintiff seeks relief in respect of several distinct claims or causes of action founded upon separate and distinct grounds. They shall be stated as far as may be separately and distinctly. This provision applies here in my submission because what was the suit for? Declaration. Converted to a partition. Distinct cause of action. It can be done, permissible.
Yes.
So this is one provision. Now, I will not trouble your Lordship with citing other judgments. Now let me deal with the judgments cited by Mr. Mithro. He has cited probably 10 or 11 judgments. Just Lordship would take note of it. I will indicate in my note. First one, 2015 Volume 8 Supreme Court Cases 331. Probably the copies have been given to your Lordship. Huh?
Compilations টা দেখি
Kindly, my lord, একবার other side এর compilation টা দিন ওনারা যে judgment গুলো দেখিয়েছেন 10 or 11 judgments I think they have cited.
Because you will also give your compilation.
I have cited two. I will give
Whatever it is,
I have given the copies. I will indicate again in my notes.
Yes, notes as well as your compilation.
Yes, absolutely. Now that konta dekhachhi dana. 2015 Volume 8 SCC 331. Probably they had cited. I will just cross-check with them if I have missed anything or added anything. From my junior's note, I find this first one. আমি জানি না ওনারা হাতে করে তুলে দিয়েছেন না কম্পাইলেশন করে হ্যাঁ একবার জজ সাহেবের হাতে তুলে দিন পরপর নেই দেখা
আপনি দেখান
এটা আবার এটাই দেখিয়েছি Mr. Yes, that's it. 2015 Volume 8 Supreme Court Cases 331. I find it whether probably they have cited Muller. I would assume they have. If they have not, Muller Lordship will ignore it. Oh, very well. So far as this judgment is concerned, it helps the plaintiff. I'm cross-checking whether they have cited or not. If they have not cited, I will not distinguish. But this judgment supports the case of the plaintiff because this judgment, 2015 Volume 8 Supreme Court Cases 331, talks about that rejection of plaint will be a drastic step. And what the court is required to be consider, para 5, that the averments made in the plaint only. That's in paragraph 5. So it helps the plaintiff. But if they have not cited, kindly ignore. Then the next one, which they have cited, is an unreported judgment in the matter of Bhaskar Gupta versus Calcutta Club Limited and others. Lordship, kindly take note of it. This judgment is also distinguishable. Firstly, the facts are totally different. There, what had happened, an interlocutory application was filed under Order 9 Rule, Order 39, 1 and 2. And the issue was not the rejection of plaint. Firstly. Secondly, the observations are very important in that decision. What is that?
This.
Yes. The Bhaskar Gupta versus Calcutta Club Limited and others.
Unreported judgment.
Unreported judgment, Millard. Now, what is that, Millard? There the issue was relating to the affairs of.
It is a reported Manupatra.
Maybe, Millard, whatever, Millard, I'm Millard placing the judgment is reported. I have no issues, Millard. Point is whether it applies or not. Reported, unreported, if it's a division bench, obviously court will consider. The main point what the court held in that judgment, Millard, that the issue in that judgment was relating to the affairs of the company. And the allegation which was made that the affairs of the company have been, kindly take note of it, have been or being conducted in a manner prejudicial to the public interest.
That is paragraph number?
Well, paragraphs which they have possibly 27, 28, 29,
28, 29.
30. So there the issue was like what happens in an application for operation and mismanagement. Affairs of the company or the affairs have been conducted in a manner prejudicial to the public interest. And finally, the courts held, though the application was Order 39, Rule 1 and 2, probably the suit was maintainable. Court can. But here the case is totally different. Here there is no allegation that the affairs of the company is being conducted in a manner prejudicial to the public interest.
Is not the case of the plaintiff.
Absolutely, Millard.
What
not
is
the case
of
here.
the plaintiff?
No. Not at all, Millard. The next one. 1971, Volume 3, Supreme Court Cases 1, 2, 4. This judgment was cited, Millard, for the purpose of meaning of the word entertain. Try, entertain, determine, and entertain. This judgment was cited by Mr. Mitro. Millard, in my submission, Millard, this also doesn't have any application because here the nature of the suit is instituted. There is a provision in CPC, Millard, I believe is section 27 or 26, institution of the suit. Once the suit is instituted, otherwise the court has entertained it. And in an Order 7, Rule 11 application, the court will consider the pleading. Why will the court not entertain? And where is the concept of entertain comes here? You are deciding at this stage whether the suit will be dismissed or not on a demurrer application before trial.
The suit should be relegated to trial or not.
That's second thing. Firstly, whether at all their prayer will be considered.
Yes.
If you find there is substance relating to certain facts are required to be gone into, then comes 14.2 for relegation.
Not the full-fledged trial.
Absolutely. Where is this concept of the question of entertaining? Section 26 or 27, if I am not wrong, it talks about institution of the suit, if I am not wrong. 26, yes. It's clear. Suit filed instituted, validly instituted. Now, if you say it's barred by law, that's not about entertainable. It's about maintainability. It's about maintainability what you are deciding. Entertaining and maintainability are the two different things.
By law means that is also not maintainable. If
That's right. That's what I'm saying.
No, if a suit is barred by law, definitely it is not maintainable.
Maintainable.
And when the maintainability comes as a both question of fact and law, an issue has to be framed.
Absolutely. And if nothing to required to be considered, dismiss it.
Yes.
Then the other one, 2025. So this judgment also does not apply.
2025 Supreme Court.
SCC Online 1208.
Vinod Infra Developers.
Vinod Infra, yes. What the court held, my lord, in paragraph 8 of that judgment, I think, possibly paragraph 8. Paragraph 8 of that judgment. Yes. May I, my lord? The position of law is that rejection of a plaint under Order 7, Rule 11 is CPC is permissible when the plaint, kindly sees this, whether it supports him or supports my case. Yes, paragraph 8.
Yes.
The position of law is that rejection of a plaint under Order 7, Rule 11 CPC is permissible only when the plaint on the face of it and without considering the defense fails to disclose the cause of action, is barred by any law, is undervalued or insufficiently stamped. At this preliminary stage, the court is required to confine its examination strictly to the averments made in the plaint and not venture into the merits or veracity of the claims. If any triable issues arise from the pleadings, the suit cannot be summarily rejected. Keeping in mind, we proceed to examine. So that's the law. And this judgment and the averments lordship would consider. Does it help him anywhere?
Plaintiff does not disclose a cause
That's
of
right.
action, and
Obviously.
the other is plaintiff does not have it.
Order 7 A and D. 11 A and D. Now read, kindly consider the plaints. I have pleaded it. Is it there? Is it apparent on the plaint, on the face of it? Plaint does not disclose any cause of action or barred by law. Certainly not. So judgment doesn't support him. It talks about the law which I accept and everybody will accept. Now, whether it applies or not, there, my lord, this plaint has to be read factually. As a whole, of course. Then 2013, volume 113 লিখে দিয়েছে সর্বনাশ। 2013, yes. 133 company cases 562. 2003, my lord, I'm sorry. 2003. There, my lord, the distinguishing features, they have cited this. Company is a juristic person, firstly. And shareholder cannot ask for partition. Here, my lord, the claim is based on inheritance. Based on inheritance.
So what was whether the subject matter of that case are similar to the subject matter of your case, of that suit?
It's not. It's not. With greatest of respect, I have read it. Company is a juristic.
Yes, unless facts are applicable.
Absolutely. Absolutely, my lord. Here, my lord, the case is somebody is saying, please partition the properties because my husband created everything out of his own fund. Group of companies were created. So right of inheritance out of the corpus, fund of her husband. Nucleus, joint family nucleus, karta. How does this judgment apply? Right of inheritance, always I can ask for partition. So this judgment does not apply to this case also. Then 2014 Supreme Court cases online, Delhi 134. Factually different. Here,
This is also 2001 Supreme Court.
No, 2000
Madras.
No, 2000. Now I am relying on.
This is Madras. What they have relied?
Yes, yes.
No, this one.
Justice Padmanabhan. Yes.
This is Madras High Court.
Yes, 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 my lord.
This is this
single bench.
This you are relying.
I am not relying.
Oh, they have relied.
I am distinguishing.
Yes, yes, yes.
All the judgments now, what I am showing, they have cited. I am distinguishing. I am saying none of those judgments apply. And why I am giving a reason to the court. Now, my lord, the next one is 2014 SCC Online Delhi 134. 1324. There, my lord, factual difference is amendment was declined in that case. If Lordship reads the judgment, their amendment was declined. Here, my lord, amendment was allowed pursuant to the court.
Oh, there were two applications, one
Yes.
Order 7 Rule 11, the
Yes.
other is amendment.
And both were taken. Here, my lord,
But
amendment was allowed.
Which one should be taken up first, whether Order 7 Rule 11
Yes.
or the amendment?
And number two, amendment was allowed when the court has categorically taken into consideration of the observation of the division bench and the single bench, when Justice Sen has categorically said while amending the plaint, allowing the amendment, that the plaint preeminently shows the existence of joint family properties. These facts are not present in this case. There the amendment was declined. And this order of the single bench is very important, which nobody has challenged. So you accept the order. So factually totally different. Then 2011 Supreme Court cases online, SCC online, Cal 1570. I think, my lord, this is probably Justice Bhaskar Bhattacharya's, my lord, division bench. There, my lord, facts are totally different.
Anyway, all these things you can take in your
I will
written
take it
notes
just
of argument.
just 2 minutes, possibly the last one. There, my lord, the ex parte ad interim order was challenged in a latest patent appeal under clause 15.
Yes.
This is not the case here. And this is a suit for partition. As I said, this is the most important distinguishing feature. Right of inheritance is involved. So these two factors are absent in that case. Ad interim order challenging a latest patent appeal, clause 15, Shah Baulal Khemji Miller provides it. And these particular things are totally different. No way it can be clubbed together. Factually, you have to show there is some nexus at least. No way. Then the last one they have cited, 1954 volume 2 Supreme Court cases 563. 1954 volume 2 Supreme Court cases 563. There also, my lord, the involvement of shareholder and the company was involved. But the important thing,
With regard to income tax.
right? Absolutely.
So with regard to income tax, is it a suit
Absolutely.
jurisdiction or REIT?
Absolutely. No.
The company for income tax purpose.
Shareholders, right, vis-a-vis, my lord, the provisions of income tax and the other thing. The appeal arises out of income tax, the appeal before the tribunal. Matter went
Appeal under the income tax act.
Yes. So lordship did not consider this at all, my lord. Right of inheritance and appeal under when you claiming a profit, that's completely different thing altogether. And the other one, the Mr. Mitra has stressed upon heavily, is on trust. Is on trust, my lord. This is an unreported one, I think, on Trust Act. That is division bench of Bombay High Court, I think. By Mahakor versus by Mangla on Trust Act. Properties held in trust can't be partitioned out of the scope. Now, my lord, I have shown you.
That was in connection with a particular suit.
What is the suit there? And what is the suit here?
Because you see, it is 1954 to SCC. It is a income tax matter before the tribunal.
My lord, there I have read the judgment. Facts and suit was completely different. Here it's a case of constructive trust.
Anyway, that upon considering the judgment, I can decide whether the facts are applicable here or not.
Does it apply to this case?
This is because this one, as it happens, it's an income tax matter before the tribunal.
Absolutely. Here, my lord, the plaintiff has categorically stated properties held in trust for the benefit of the legal heirs.
Yes.
And the concept of constructive trust is there.
Right.
If there is a breach,
That too also has to be decided at the time of
absolutely,
trial.
my
Or
lord,
not.
absolutely,
That is
absolutely,
also to be said.
absolutely, absolutely. So my submission, considering this, my lord, lordship should reject the application. Number one, should proceed for trial. Alternatively, at best,
That issues can be framed. Preliminary issues.
should decide at best. These are my submissions, my lord. I will prepare and give a note.
Mr. Sen, you reply on the next date.
My lord, could it be kept on 12th of December?
Okay, 12th of December. We'll conclude on that date.
My lord, we'll endeavor to.
Your Lordship, if you see the master summons, it says the claim should be rejected against 34.
Oh, you have completed your submissions.
I'm just printing a bit.
No, because you have to give your written notes also.
I will give a written note also.
No, because after Mr. Sen or Mr. Mitra concludes, so you file your written
Yes,
note.
it's on that day itself.
Because after 12, probably these 2 weeks, this bench will not sit. After 12.
But I would not say anything, but
I'm keeping it on 12.
I will kindly dispose it of at the earliest, taking into their convenience.
Yes, record and order. Learned advocates for the parties that are present. Mr. Dev, learned advocate for defendant number 36. Submits but could not concludes his submissions. Let the matter be fixed on 12/12/2025 for reply by the
plaintiff.
Reply by the applicant.
Defendant number 1.
Applicant, defendant number 1. Yes. So you will have to file written notes thereafter. Probably.
On that day itself, I am considering or lordship, my lord will be going to circuit.
Yes, yes. Probably on the next to the after 12, 2 weeks I will not be available.
My lord, may I make a prayer to your lordship, subject to my lord's convenience?
No, 12th. Let Mr. Sen conclude. If you are ready.
I was suggesting, since lordship will not be here for 2 weeks, would it be, my lord, if lordship, if they are otherwise not preoccupied, takes it up on Thursday and give a date on Friday to hand over the notes, then lordship will do it in your lordship's time.
Okay.
Thursday at 3 p.m.
On Thursday, do you have any difficulty?
Thursday mane
on
11th
11th.
Yes.
You have any difficulty
at 3,
on
lordship
11th?
will hear them for 1.5 hours, and Friday notes, matter will be over.
My lord, Mr. Mitra, my lord, will possibly not be available on 11th. My lord, that's the only difficulty.
Do it on 10th,
Anytime,
11th.
which is why, my lord, the request is being made, my lord, from our side. My lord, Mr. Mitra will not be available.
Anyway, let it be on 12.
Very well, let it be on 12.
Let this matter appear on 12/2025.
But at the top, otherwise there will be some confusion. Lordship takes it up from 12 onwards.
Yes, 12/12/2025. Definitely at 12.
Yes, yes.
I am taking this matter at 12.
Yeah. Continuing matter, let this be over, my lord.
Yes, yes.
Let it
Concluded
appear
on
at
that date.
At the top, my lord, only, my lord, only.
Yeah.
May it appear at the top.
At the top. দরকার নেই, ওটা usually 12 PM এই থাকে।
We'll just see the summons. They said rejected against 3 to 34. And it will be continued against the other defendants. 3 to 34 goes, so the plaintiff will continue the suit against defendant number 1 and 2, and 35 to 39. How can that be done? It is a short point. I don't have to go to any of these cases.
We'll satisfy your lordship. We'll satisfy your lordship.
Anyway, let Mr. Sen satisfy.
We'll satisfy.
If he can satisfy your case, will go. He will succeed.
12.
Yes. On 12th, if Mr. Sen can satisfy, your case will go.
Yes.
And Mr. Sen will succeed.
Yes.
I'm grateful.
Wait till 12th.
And thereafter, if you can come with your written notes, well and good. And if they cannot conclude on 12th, what can be done? It has to be kept on some other date.
Well, we'll endeavor to conclude on.
The endeavor.
My lord, in reply, my lord, I tell, in reply, lordship knows, my lord, only on law.
Yes, yes, law points, no new points.
They can't cite a new, my lord, only they have to deal it. Hopefully, they will be able to come.
Okay, thank you.
Great, grateful, my lord.
Item number 50. What a kill.
Yes, sir.
And for the respondent number 2, my lord.
Okay. Sir.
And for the respondent number 2, my lord.
Okay. 50. For the appellant.
Miss Puchorita Paul.
Okay, not today then.
Then kindly fix the date, my lord. Otherwise, it is fixed at today at 2 p.m.
Yes,
But
my lord.
because
Let
why,
it,
why,
okay, let it appear on Monday as to be mentioned. Thereafter I shall fix
my
it.
lord, why this matter was?
No, I'm
I
keeping it.
filed an application for withdrawal of some amount. My lord, since that application is there, my lord was of the view that since the paperwork has been prepared, matter may be
Okay, I'm keeping it at to be mentioned on Monday. Thereafter I shall fix it.
My lord, is it possible to fix a time on Monday? It would
To be mentioned. In the very first it will be taken up.
Since it is already fixed for hearing today 2 p.m. Kindly make it fixed for hearing on Monday 2 p.m.
Let it be a to be mentioned on Monday.
But again, it will be
If
delayed.
both sides are present, I'll take it up.
My lord, kindly contain both sides. In presence of both sides, the matter has been fixed for today.
Very well, very well.
Let
So,
it be fixed on Monday 2 p.m.
no, Monday to be mentioned. Okay.
But otherwise, the matter will be delayed. My lord, again, winter vacation will come.
No. I shall see that it is taken up.
My lord, kindly taken that.
Monday to be mentioned.
Grateful, my lord.
Inform the other side.
Item number 20.
Yes, Your Lordship. Your Lordship, this is my appeal, Your Lordship. Lordship, this is the affidavit of service.
Delayed. My lord, again,
The delay of 3 days, Your Lordship.
Yes. This is can 2. Can?
The
Can 2.
Can 2, Your Lordship.
No, can 1.
Can 1 is the condonation of delay and can 2 is the stay
stay
petition.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. The application for condonation of delay being can 1 of 2025 is taken up for the consideration. Peruse the petition. Considered. Upon perusing the petition and hearing the learned advocates, the delay of 3 days in filing this appeal is condoned. The appeal is admitted. The application next can 2 of 2025. The application for stay is taken up for consideration.
Outright deposit is there.
The statutory amount.
Yes.
Yes. You are for the opposite.
I'm for the respondent claimant.
As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 19th August 2025, passed by learned additional district judge, first court at Alipur, South 24 Parganas, in MSC case number 1023 of 2023 for a period of 5 weeks from date.
4 weeks, man. 4 weeks, me kindly.
All matters are passing.
Yes, same order.
The appellant insurance company is directed to take steps to deposit the entire awarded sum along with interest from the date of filing claim case till date of the deposit, excluding the statutory amount. Stop. In the event such deposit is made, the ad interim order of stay shall continue till disposal of this application. The execution case pending before the learned trial court.
Execution case number.
Execution case being
72 of
being
72 of 2025.
being 72 of
25.
72 of 2025.
Yes, Your Lordship.
Shall also remain stayed for a period of 5 weeks from date.
Lordship.
And in the event the deposit is made till disposal of this application.
My lord, the appellant may kindly be directed to serve the copy of memo of appeal upon me.
Memo of appeal. He's asking for memo of appeal.
Let
We
the
have
copy of the memo of appeal be served upon learned advocate.
And my lord,
The respondent number?
respondent claimants.
Respondent claimants.
My lord, another indulgence I am praying, my lord. The order of paper book may kindly be passed, my lord. Then matter will be expedite, my lord.
He wants to make
The respondent number 1 is granted liberty to file the paper books.
Informal paper, my lord.
Informal paper books within 1 week from the date of reopening after vacation.
Yes, my lord, and LCR may kindly be called, my lord.
The trial court's records are called for. The trial court's record be called for.
And my lord,
Liberty to mention.
Liberty to obtain the certified copy from the paper,
Okay.
from the certified.
Upon arrival of the trial court records, the learned advocate for the respondent number 1 is permitted to apply and obtain certified copies and prepare the paper books.
Your Lordship, as the
You appear for both claimants as well as insurance companies.
In some only one company I am panel.
Your Lordship, and communication order to be communicated as attachment has already been
Yes,
given.
I have stated the execution case.
And to communicate the server copy, so that that
The
will help.
server copy will be made ready today.
I am appearing, my lord. I am appearing.
No, before the executing court. Because that has to be
Yes.
communicated before the executing court.
Yes.
Yes, liberty to communicate server copy of the order.
Deeply.
Yes, call the original site.
2 p.m. Passover matter was there.
Huh?
At 2 p.m. Passover matters were
Yes,
there, my
2
lord.
PM?
My lord, Passover matters were there. There were 6 matters.
Oh, just a minute. You
My
let
lord.
the original site matters become taken up.
Original side, item number 2.
Yes, my lord. I am plaintiff number 1, my lord. My submission be heard and recorded for necessary inspection and action of your lordship. We 10 owners of victims and rely on your lordship. My lord, last order of
No. Today,
Is-
today is the date
Today-
for production of the document.
Correct, my lord.
production
Absolutely.
document and
My lord.
witness action of plaintiff number 2.
Yes.
My lord, witness is before the honorable court.
Yes, where is the state
Yes.
government advocate? What?
I am producing the register, my lord, containing the orphannama.
No, you are representing the authority.
Yes.
The authority, yes.
Okay.
Yes, the witness is over here.
The witness,
Down.
my lord, is there. One thing, my lord, I must inform your lordship, my lord. The document that is being produced, my lord, it's a very old document. Your lordship knows, you know, 1905. So, my lord, that obviously, my lord, should be marked, but no photocopy, my lord, can be made of it. If your lordship directs, my lord, it can be scanned by your lordship's officer, or we also have a scanned copy, my lord, which we will produce to keep in the record.
Or some true copy has to be obtained
Yes,
in
yes,
some other way.
Yes.
True copy.
Yes.
Earlier, when there was no Xerox, some true copies were to be obtained.
Absolutely.
Certified copy also will have to, I don't know, my lord, if it's there. Your lordship will see the document, my lord. You
Both parties verifying
Yes.
along with the state government advocate.
May I just?
Yes.
I also
Yes.
want to enter into questioning.
Yes. You will get a chance to cross it.
You are appealing for? Defendant number 4A and 4B. Defendant number 4A and 4B.
Before it comments, my lord, I have one respectful submission before your lordship.
See, government authority can say
Solemnly
something from the record.
Solemnly
Government authority
affirm
will
that
not have any
affirm that
knowledge of the
whatever
facts of the case.
I will depose
I will
Yes.
depose
by way of evidence
by way of evidence
in this suit.
in this suit.
I shall speak the truth
Speak the truth,
and no part of it
no part of it
shall be false,
shall be false,
and I shall not
and I shall not
conceal anything.
conceal anything.
What is your name, madam?
Shemonti Shikdar.
Give your identity card.
Identity card.
CSEMANTI. Shemonti
Shikdar.
Shikdar. SEMANTI. SIKDAR. Shikdar. Your husband's or father's name?
My father's name, late Sunil Ranjan Shikdar.
Late Sunil Ranjan
Shikdar.
Shikdar. Age,
39.
occupation,
Government service.
residential address,
706 SHKB KB
SHKB.
Sharoni
Sharon.
KB
Okay, B.
Sharoni
Sarani,
Kolkata 700 7000074 74.
Miss Shikdar, why are you before this honorable court?
I am here on behalf of Register of Assurance. He authorized me. This is the authorization letter
Not now. He authorized me. You continue to
to present the volume here as per volume number for 1904.
1904.
How has
regarding
Regarding
case number?
CS case number 41 1989.
41?
1989.
Yes.
Have you received any document from this honorable court?
Yeah, I got a subpoena from here.
Yes, I have received a subpoena. From
For what purpose?
Keep it with you.
Chief. Shall I?
Yes.
What was sought for under the subpoena?
To produce the volume number 4 of 1905.
The subpoena is tendered in evidence and be marked as exhibit. Subpoena ta din?
Original document?
Subpoena and the authorization letter.
That I will also.
No, she has stated that she has.
Yes, I will certainly. Subpoena be marked as exhibit. No, please don't mislead the court. Please sit down. There have been documents which have been marked as exhibits earlier. Yes, in 2014. CS 41, 1989. Shall I proceed? They will find out there's exhibit numbers and put things.
Yes.
Has the registering authorities issued any letter of authority in your favor?
Yeah.
Kindly, who has
Register of Assurance authorized me to present here.
Who has signed this?
Register of Assurance.
Who has signed that letter of authority?
Register of Assurance Aninder Sundar Pradhan.
Has he signed in your presence?
Yes.
Mr. Anindra Sundar Pradhan.
Has he signed in your presence?
Yes.
Are the contents of this document true and correct?
As per available records.
This document is tendered in evidence and be marked as exhibit.
Yes.
Yes.
Have you brought the document which was requisitioned under the subpoena?
Yes. Original volume copy. I did.
Yes. What is that document?
An Orpon Nama, bid number 78.
ওনাকে ডকুমেন্টটা দেখান ডকুমেন্টটা খুলে লিখে
Page number 53.
ডকুমেন্টটা খুলে দেখে বলুন
Too damage to be there.
উনিশশো 5 তাই তো 120 বছর ওনাকে দেখান এই মাইকটা একটু এদিকে টেনে অরিন্দম মাইকটা এদিকে টেনে দাও, তবে উনি দেখতে পাবেন ডকুমেন্ট নাম্বার গুলো।
ডিট নাম্বারগুলো আরেকবার বলে দিন।
Sheet number 78, book 1, for the year 1905, recorded between 50, page number 53 to 58.
Who has executed this document?
No, no. How she cannot know about the
Contents.
about this executants already. Whatever there is in the record, she will depose.
Only the date. Then I will just ask.
Yes, yes. At best.
At best.
Yes.
What is the date of this document?
1311 Bongabdo, 25th Poush. Poush. Bengali document.
এটা ঠিক আছে, বেঙ্গলি
Bongabdo.
বঙ্গ। হ্যাঁ can you please state the English date of this Bengali date?
9 January 1905.
Is this the original volume copy of the original deed of Orponnama?
As per record section, as per record available, yes.
Yes.
This
As per
document.
the record, it is so and so.
Great. This volume copy is tendered in evidence and we marked as exhibit.
Yes, and this has to be returned. True
Yes.
copy has to be returned.
Yes, yes, ma'am. Absolutely. Like we do in the learned codes below, the original
My
voter
lord, I have
card,
some questions.
Aadhaar card. Now, yes, you will get an opportunity. You make they keep a copy.
No, but so far
written.
this is a old volume. It cannot
Fragile.
be xeroxed.
No,
Some other way you have to prepare it and get it certified.
It will get it scanned. They will take a printout and she will.
Yes, yes.
And with an undertaking that she will produce this copy as and when directed by the court. If the court intends to see it anytime, then the court is.
You have this is a chief on behalf of plaintiff.
Plaintiff 2 series.
Plaintiff 2 series. Yes, from defendant sides. Anybody want to cross-examine?
No, no. Yes, she.
No, defendant who is appearing. You.
I'm defending
Anything to cross-examine?
No, ma'am.
Okay.
Madam,
Cross-examine.
Number 3, my lord, we are not any other.
Okay. Cross-examination refused on behalf of defendant number 3 and
4.
4.
3A, my lord.
3A and
4A and 4B.
3A, 4A and 4B. Yes, if you want to put, you are for plaintiff number?
I'm plaintiff number 1, my lord.
1. Yes, if you want to put any question.
Cross-examine in detail.
Yes, whatever you want to put, but it must relate to the records, not from
Yes,
your
my lord.
imagination.
Yes. Miss Shikdar,
এটাকে টেন্ডার
can you
টেন্ডার
prove?
থার্ড জাস্ট সেকশন এটাকে থার্ড এক্সিবিট মার্ক করলেন তো, এই যে ডকুমেন্টটাকে থার্ড এক্সিবিট মার্ক করলেন, ওখানে একটা ছোট, আপনি তো এক্সিবিট মার্কিং করতে পারবে না, একটা ছোট চিরকুট ওখানে লাগাবে, হ্যাঁ, লাগিয়ে ওইটা মার্কিং হয়ে থাকবে ডকুমেন্টটা, যখন ফেরত যাবে ওই এক্সিবিট ওই মার্কিং নিয়ে ফেরত যাবে, ঠিক আছে? হ্যাঁ, একটা চিরকুট ওখানে আসবে, একটা ফ্ল্যাগ লাগাবে,
Can
ওই
I start,
নিয়ে
my lord?
তার এক সেকেন্ড একটু মার্কিংটা করিয়ে দিই, কেন এতে সিল মারতে পারবে না, আর
থাকবে
আর সাদা কাগজ দিয়ে
এই
মার্ক
ওটাকে
করে।
ইয়ে হয়ে গেলে মানে ওটা ট্রু কপি প্রিপেয়ার হয়ে গেলে একটা ইয়ে করে দেবেন, সার্টিফাইড।
হ্যাঁ, হ্যাঁ, there will be a formal direction from my lord that he will make a true
It will be
copy.
certified.
Yes, yes.
এখন
সিল মেরে ওটাই
ঠিক আছে, ওটা খুলে গেছে।
and she will now cross examine.
Yes.
Miss Shikdar,
Yeah.
please tell my, your Shikdar, Miss. Yes.
আপনি এদিকে আসুন,
Please.
Kindly tell my lord, who are the donors' name you see in this
No,
document?
she cannot say anything about the document, only from the record.
Say, my lord.
She cannot say, you cannot put this question. Whatever she will
Here
say,
is the document, my lord. We can see. I can help
she
her.
is not supposed to know about the contents of the
My
document.
lord.
Yes,
The
this.
donors' names are found.
No, refuse. Put some other questions from the record.
Yes, Miss Shikdar, how can you prove that this particular document is pertaining to the premises at 13 Kaliprasad Chakraborty Street, Calcutta 3? If you can't do it today,
madam.
please do it tomorrow. My lord, these are very important questions.
All questions can't be put to this witness. Only she can say from the record, not something beyond that.
Record is there.
Whatever is there, she
Is there.
is not supposed to.
That means
She's
suppression
not
of fact.
supposed to have knowledge about the contents of the
I
document.
know, but she will take time. She will come back.
No question of taking time, please.
Well,
Does not know the law of evidence.
kindly wait, my lord.
Which question she can put in the.
3. Without this verification, this
It is not necessary. I
this
tell you
government paper is invalid.
very well, very well.
Number 2.
Yes.
Kindly try to understand.
I don't have anything to understand you. Please put the questions.
Slowly. Miss Shikdar. Miss Shikdar, kindly tell my lord how this matter was copied here. If you have no knowledge, can you please come back next day and explain?
No.
That this particular
Document was copied from original document made by Bhuvan Mohan Niyogi. This eta likhun question.
It's registered in 1904.
Just give your
How can you prove that?
Okay, please slowly. They can't.
How can you prove?
Just a minute.
My lord, I am helping this court to understand. How can you, Miss Shikdar, you are from Assurance
Register of Assurance.
Register of Assurance Company. How can you prove that this particular document was done by donor Bhuvan Mohan Niyogi at 13 Kaliprasad Chakraborty Street?
লিখেছেন কোশ্চেনটা?
If you can't prove today, please come
but
next
slowly.
day.
Let her give the answer first.
লেখা হয়েছে কোশ্চেনটা?
ও পারবে না বলেই ওকে আমি হেল্প করছি।
Yes, do you have any knowledge about these documents? Yes, record that I don't have any knowledge about the documents.
এবারে বলুন next question.
Next question, can you please give this proof that it was originally done by Bhuvan Mohan Niyogi of 13 Kaliprasad Chakraborty Street today or tomorrow or next day?
No, I can't.
Yes, I will
I
record.
don't know this.
Record. I cannot say.
I cannot.
Without this,
She has
is
stated. I
invalid,
cannot
my
say.
lord.
Very well. She has
Yes,
stated. I cannot say. You have asked the question. She stated. I don't have any knowledge.
it should be taken into account.
Yes. I shall take that
This
at
is
the time of
invalid.
time of
Can you
argument. I
please
shall take that.
Most important question, my
Very
lord.
well. Any other questions, please?
Can you explain in what process these papers were ready? What is the process by which
লিখেছেন কোশ্চেনটা?
registration company, registration department of West Bengal make this
You
copies
see,
of original?
please read the question. Question ওনাকে বলুন তো কি বলেছে?
Can you explain it? The process.
This is the original volume copy.
How can you prove that original copy has been verified by department at RA Raju's registration office and has been copied there? What is the proof of verification?
It was apparently registered in 1905. How could I tell you that?
What is the process? My lord, I tell you on this.
লিখেছেন ওটা কি বললো?
Registered in 2005.
Beyond knowledge. Beyond our knowledge.
ঠিক আছে.
I say, my lord.
Very well. Very well. Is any other question, please?
How can you prove that this original document is connected to 13 Kaliprasad Chakraborty Street, eta likhun, and it has been this Orponnama has been done by donors Bhuvan Mohan Niyogi and
I think it was a previous question, my lord.
My lord, I would just object to it. This is, she can't say anything with regard to the contents of the document.
That will be recorded.
Question.
No, what's
My
important
lord,
my lord, question I don't understand.
I want to know what is the
Let
process by which this copy has been done.
কি কোশ্চেনটা বললো বলুন তো একটু, just a minute.
How can you prove that this original document is connected to 13 Calcutta Chakraborty Street
And has been
and this Orponnama has been done by donors?
Acha, do you have any knowledge about the documents? Yes, record that. I do not have knowledge about the documents.
then without which it becomes invalid?
Very well. I shall continue. Yes, any other?
Yes. How can you assert that there are only 2 donors' name in this copy? That is Bhuvan Mohan Niyogi.
Can you say anything about? Yes, record that. I cannot say. I cannot say.
And not in this regard, I just want to add, there it is ancestral property. There are many co-personers. So only 2 co-personers cannot make a deed on a property themselves without taking consent of all
co-personers. That
Matter
is
of-
in accordance with law. It is the simple conscience of Calcutta High Court that only two donors cannot enter into any property deal or property deed without taking consent of all co-personers. Under these circumstances, this Orponama seems to be invalid. My lord, I know myself that if we take any paper that would have been copied without verification, whether who is Bhuvan Mohan Niyogi, who is Annapurna Dache, and nothing else. So, original copy is lost or some fabricated copy has been done over there. I request Calcutta High Court to make a probe into that. And also, my lord, your lordship cannot skip this type of infatuous and suspicious event, my lord. A simple fabricated document has been copied over there.
Yes, that's all.
Yes, that's right.
Yes,
These
your
are points of-
position is complete, please.
She cannot.
I will bring the
whether
next
it-
witness.
whether-
Madam,
Yes,
and
it's
the next-
complete. Okay. Yes, you may.
The witness is present. Must be discharged.
Her presence also.
Yes.
My lord, another question comes.
That questions will be decided at the time of hearing of the suit.
One moment. Plaintiff number 2B2 is contending the petition suit.
You see, you are
Cannot be
first of all,
plaintiff
you are confused. You are confusing everybody. If you want a no. If you want, you see, you cannot proceed in this way. If you want, I shall refer your matter to the Legal Service Authority.
That was done, my lord,
Let a lawyer be engaged.
my lord, that was done by the Honorable Chief Justice. Once the matter went before the Honorable.
My lord,
Eh? Eki?
I cannot allow this type of.
My lord, was just final.
Kindly
This was
No,
done
you are
by the
confused. You are confusing everybody.
Honorable Chief.
Can your lordship prove that this is original?
Very well. I shall consider that. I shall consider whether I can.
This
You
is
are.
original.
You see.
Secondly, my lord,
You are
your lordship
totally.
is judge. Your lordship is judge. You are observing plaintiff number 2.
Yes, record an order, please.
আপনি রিলিজ করে দিন
You record an order.
রিলিজ
14 of the honorable judges has
My
released
lord,
this matter
please.
due to our behavior, my lord.
Hey.
Next, her appearance
আপনি
will
release
be because of my lord, personal appearance, my lord. My lord, she
আপনি-
cannot.
Yes,
She doesn't
just a
know
minute.
the record of the court.
Learned advocate.
এইসব অ্যাডভোকেট ওখানে তামাশা আসছে আপনার সামনে
Learned advocate.
without
Plaintiff. That is the witness which is present today as PW.
PW1. No, she
এখানে
has
সব
deposed
পক্ষ আছে।
PW2 হবে এটা।
So this is PW.
2. She
Two.
has deposed.
Okay, PW2.
PW2.
And learned advocate representing defendant number 3.
4A.
Defendant
4A and 4B, Devkumar Chandra.
আপনি
PA
বুঝতে পারছেন না এটা সত্যি
and
কি
defendant number
Please.
4
Devkumar Chandra for 4A and 4B.
are present.
আপনাদের কি ডকুমেন্ট
Number 1
আমার
and
নামটা লিখে দিন।
discharged.
my lord,
The
Deputy Commissioner.
other parties have declined that. they
uh,
want to talk.
the cross-examination by all other parties have been declined. The original volume which is produced in court today and marked exhibit be returned and a certified copy be made ready and be kept in the court file.
My lord, team of officers should
By
study
any way,
my-
by whatever means, let a certified copy be prepared and kept in court.
My lord, team of officers should study.
So what else should,
This cannot go on, my lord.
please,
This is a-
please be quiet.
My lord, when the Honorable Calcutta High Court should frame rules, my lord, how parties would appear in person, my lord.
আপনি তো
A
একবার
fit
হচ্ছে
person should appear in the court of law, not a
Yes, sir.
fit person, my lord.
So,
He is unfit for that. Without
learn- as the plaintiff is appearing in person and as the plaintiff is in appearing in person and being confused is creating annoyance in the court, this court is of the view that this matter should be sent to the legal service authority for appointing a lawyer in this behalf. Let the copy of this order be sent to High Court Legal Service, Secretary High Court Legal Service Committee
I cannot,
to
I am
appoint-
present, I cannot appoint.
to
I
appoint.
cannot appoint.
Therefore, if that is so, then I will not permit you to say anything in this court. If you don't take a lawyer,
No, I won't take.
I will not permit you to say anything in court. No, no, no. The court is not bound to release it.
Release what is the interest of the law?
The matter is assigned to me not to release, but to take it up.
No, I cannot allow any advocate. Sorry.
Very well, then I will not permit you to say.
Then release it. My lord, kindly release it. My lord,
Okay, your other side is not present.
They knew that at 3 p.m. it will be.
Mr. Rupak Ghosh is to submit.
Yes. Mr. Ghosh is supposed to make his submission.
So I'll take it up after 10 minutes. Let him come.
Let him come.
I'll 3-5 I shall sit. Mr. Rupak Ghosh has come.
Well, he has not, yes, well, may I,
Anyway, then
no, may I just say one thing?
yes.
While I had argued with your lordship that the suit for administration also can be used as a partition of the properties. And this proposition I had argued, to which Mr. Ghosh was replying, and he said that I have not cited any judgment on that point. So, my lord,
No, you will cite. When you will give your written notes.
no, they will not get a chance to deal with that. That is what I am saying. I can add it in my written notes, but this, unless I give this judgment, refer this judgment formally to your lordship, they will also not have the chance to deal with that judgment. So I should be fair, my lord.
Anyway, so let him complain. Let him submit. If you want to rely your judgments, you give him a copy.
No,
I will. I will. No, today I can give it.
Further judgment or going to make further submission, then let them complete altogether. Then let us.
No submission. Only judgment.
Submission.
Only judgment. Nothing.
Only judgment. Only
So let him come. I just give me 5 minutes. I have some appellate side
no,
matters.
but what I am saying, what I am submitting.
Yes.
Today is 3:30 is there.
Yes.
So we are having 10-15 minutes time in our hand. So Mr. Ghosh perhaps is busy in other court. I understand. He is understand. So let me formally cite this to judgment in the meantime. Let the copy be given to him.
Let Mr. Ghosh delete on the next.
That is what I am saying. That is what I am saying.
I hope these two judgments will support my case.
Maybe.
I hope so.
Maybe.
So may I also get an opportunity of dealing? Because
of course.
I have to reply to Mr. Rupak Ghosh's submissions also.
Yes, my lord, these two judgments, one is
yes, Mr. Ghosh has come.
Of our Calcutta High Court judgment.
Yes, Mr. Dotto wants to give some judgments. You will deal with those in your submissions on the next day.
So I am not called upon today.
No.
That's the only.
Because on the last occasion you said that your learned friend did not cite the judgment.
So my learned friend has come.
So your learned friend said several judgments, but he has not given one.
Let my learned friend cite.
Yes. I mean, you copy my lord, the first judgment, my lord, is reported in year 1935, Calcutta.
This is the judgment I was also.
You are also relying on. I think it's a common judgment. He will also rely on this.
I was also.
35 Calcutta 39. It is a division bench judgment of our High Court.
1935 only.
My lord, I'll
take your lordship's leave.
He will take a note of that.
So next date,
my lord,
Junior will inform you.
Yes, I'm just there. Let me just, my
lord, at page 45.
That is AIR 1935 Calcutta.
35 Calcutta. Yourself ke boita de. So boita 35 টাকার ওটা বোধহয় আছে। May I hand over a photocopy of that judgment? এটা তো তাহলে সেদিনকে কি তাহলে থেকে যাবে?
Yes.
Well, kindly come to page 45.
45. Page 5.
Well, মিলবে না? My God.
I can give my copy.
Yes.
I've also carrying the same.
Actually, now we are habituated to go through this copies. Earlier, this handing over this Xerox copies was not accepted.
I come from that old school, so I rely.
No. Earlier that was appreciated.
This my learned friends,
yes.
They are habituated.
No. Earlier, during your time, that was appreciated. But this was submitting copies was not appreciated. But now it is the other way.
I'm told that the seniors, my learned friends on both sides, seniors used to have 3 sets of.
Yes. It is to come from the.
At least.
From the judge's library, it is to be called as.
I didn't have that accommodation in my house, so I maintained only one.
No, but then,
Everybody had almost.
my lord, may I hand over my copy because I was,
Give a.
That is AIR.
yes, my
Same,
lord,
same,
because I
same.
was also relying on the same judgment.
So let me take down the citations. Okay,
Yes.
I shall go through this.
No, but I. No, my lord, I was only the
Yes, AIR.
relevant portion of that judgment.
Nature of,
To that book because that will match my learned senior. That is why it has been given to your lordship.
35 Calcutta, page 39.
Page 39. At page 45. Now, my lord, kindly come to page 45. It is paragraph number one.
মেনশন করেছি কবে থেকে? 19
আপনি আমাকে দিয়েছেন একটু
Paragraph number করে দেন।
ওখানে ফাইল
প্লাসিডেমনি।
so there is heading টা রয়েছে nature of the suit.
ওটা হেড নোট পড়িয়ে তো লাভ নেই।
No, no, no.
My lord, first kindly come to the head note.
Page 45
Yes.
as a nature.
Head note, administration suit. The nature of suit is in essence one for accounts and application of estate for satisfaction of all creditors and for beneficiaries. But that is
Yeah,
the
they also have dealing with another matter, partner, that is partition. That submission, that same as an
same
administration.
as that of the administration.
That submission was
And
made.
in administration suit, there is also preliminary degree. Now, my lord, kindly now at page 45. Kindly come to page 45.
Yes,
Towards the right hand side,
yes,
page 45, my lord, kindly see the left hand side bottom.
yes.
Nature of the present suit. Heading. The next question is, what is the true nature of the present suit? Mr. Das strenuously contended that this is a suit in the nature of administration action. Administration means the management of the estate of a deceased person who has left no executor. The object of an administration suit is to have the estate administered under a decree of the court. In such a suit, the whole administration and settlement of the estate are assumed by the court. The suit in its essence is one for an account and for application of the estate of the deceased for the satisfaction of the dues of all the creditors and for the benefit of all others who are entitled, and the court marshals the assets and makes such a decree. Now, my lord, this is the whole object of the administration suit. Now, my lord, kindly come towards the bottom of that page.
Yes.
The prayers in the plain have potential years, but the prayer may not tell you with, because it varies from plain to plain. That is not the criteria. Criteria is the object of the suit. The whole object may not be simply stated a partition suit in the nomenclature. It is an administration suit, but administration means administration of estate for the benefit of the creditors as also for the beneficiaries.
For the beneficiaries, that means, you see, executors has left without any, the testator has left without appointing an executor.
Which court can appoint?
So this is the case of this administration.
The same thing is here.
Partition is also means the owner died.
Partition.
Owner died, leaving behind the co-sharers.
Co-sharers.
So it is
dispute between them.
Here it is the several properties of co-sharers, and they have come to court seeking administration.
Administration. So therefore, it is administration is not exclusively for the accounts, but for the administration of the estate.
That means, according to you, the object of the suit is to be considered.
Absolutely, absolutely. And this object, my lord, has to be taken into consideration with the intention of the parties. With the intention of the parties is to divide the properties amongst themselves. And how it has been divided? It has been divided mutually, recorded in several minutes, which were acted upon by them.
Anyway, I shall consider this decision.
Yes, definitely. Which were acted upon by them means after the division of the properties mutually by them, recording in a particular minute, or not one, several minutes, then the properties which have been allotted to the respective group, that group has also sold and conveyed some of the portion of that.
Because you see, one thing here, the difficulty is there is no a preliminary decree in this.
I'm sorry, the preliminary decree.
That declaration is not there.
No, preliminary decree.
That means one hurdle crossed, the
Yes,
preliminary
yes,
decree is
yes,
passed.
yes. But here Lordship will find in this suit number of orders have been passed from time to time, including the division bench judgment, and division bench judgment has also categorically stated that I remain out of the dispute among the two groups insofar as my lot is concerned. I have already given that copy of the order.
And you are in exclusive possession of a particular portion.
Particular portion.
Whether all the co-sharers have expressly or impliedly admitted.
Absolutely.
That is to be seen.
That is to be seen. That will be seen from the record itself.
Record, and you clarify it in your written notes of submission.
I will do. My lord, this judgment was subsequently relied on by another division bench of Nagpur High Court. This is division bench, my lord, comprising of Chief Justice Sinha and DOJ. My lord, this is reported in AR 1953 Nagpur 276. বইটা আছে তো? My lord, may I hand over a copy? Fortunately, I have a copy.
Okay.
এটা তুই জানিস নি বোধহয়।
আমি পেরেন্টটা নিয়েছি।
পেরেন্টটা নিয়েছি। My lord, kindly paragraph 5. Kindly come to paragraph 5. The reference to লিখেছো? Paragraph 5. The plaintiff gives the details of the property and the nature of the debts and other liabilities to be paid off, and further states the plaintiff number 1 to 3 are entitled to half share in the remaining property. The creditors are joined to enable the court to ascertain the debts and help the administration of the estate. It is stated that the plaintiffs do not insist on partition till defendant number 1 becomes major, and that till then the estate should. This is the case of the plaintiff. Now, under this background, my lord, kindly come to paragraph 11. Para 11. The only contention that was strenuously pressed before us is that the suit is in substance one to enforce the plaintiff's title to the property in suit against a person said to be in wrongful possession, though the grab is that of an administration suit. The contention seems to be that the plaintiffs must value their suit under number section so and so, Court Fees Act. The Learned Advocate General contends that the plaintiff suit must take the form of a suit for possession of their reality. The argument of the Learned Advocate General proceeds on a misconception of the object, nature, and scope of an administration suit. Administration is management of the estate of a deceased person who has left no executor. It consists of getting in the debts due to the deceased and collecting his other assets, payment of funeral expenses, payment of his secured and unsecured creditors, payment of pecuniary and other legacies, and after deferring the cost of management, final distribution of the remaining estate among the residuary legatees or amongst the heirs, as the case may be. Well, that is the object. That means the administration suit, the administrator will meet all the liabilities of the estate, and after meeting all the liabilities, my lord, the residue, whatever would be there, that will be distributed amongst the heirs, amongst the legatees. So the same principle would become applicable. In fact, my lord, this principle has been followed from the logic of the judgment laid down in 1935 Calcutta. Now, my lord, may I just proceed further? My lord, let me skip few lines from this. The same paragraph 12, the last 4 lines, my lord, kindly says. Will pay off all the liabilities of the estate, distribute the remaining estate to the legatees in accordance with the will, and after the estate is duly administered.
No,
to
that is
hand over
paragraph number?
the same paragraph,
That is-
paragraph 12 continuation.
Yes.
The last 4 lines, last sentence starts from distribute the remaining. Distribute the remaining estate to the legatees in accordance with the will, and after the estate is duly administered, to hand over the residue to the legatees entitled thereto, or to the heirs if there are no residuary legatees. So, my lord, Lordship has to consider this particular proposition from the this proposition that court always tries to, my lord, to put an end of the litigation as quick as possible.
Within the framework of the plaint. Okay.
Yes.
Within the framework of the plaint.
Framework of the plaint. My lord, it is not the intention either of the parties or of the court that after completion of administration, payment of all liabilities of the estate, thereafter the parties will file a partition suit and go for another 50 years for getting the property partitioned by either meets and bounds or other way. That is not the intention, that is not the object.
The application of Mr. Ghosh's client, which all of you are proceeding, will put an end to this litigation.
Absolutely.
That is to be
that
decided.
That is what the law wants. And that is why, my lord,
that is,
not only
if
my
that
lord,
can put to an end,
my
then
lord,
the
this
matter
is the
is decided.
intention of the parties. Intention of the parties.
Yes.
Parties, in fact, had intended that they want to put an end of this litigation by virtue of the division of the properties jointly and amicably. And in fact, they have done so.
Yes, and from the, you see, from the 4 corners of the plaint, the relief which you have sought, the nature of the suit, whatever is permissible under the law, that the court will consider.
Yes, my lord, that is
put an end to the litigation.
That is why 35 Calcutta said that although it appears to be a suit for administration, which is for suit for accounts, but also after meeting all these things, it can be divided and it can be given to the legatees or the heirs.
Yes.
Otherwise, my lord, there is no other meaning of this judgment. This judgment means only that.
Yes, let us see how far this can be applied.
Definitely. So, my lord, this has to be read with, my lord, the several minutes which I have annexed, and they have also annexed. Several minutes they have annexed, and how they have acted upon that. Because if it was not the intention of the parties to division the properties, partition the properties, these things could not have done. And this
Only
has been
thing, you see, that your hurdle is this: you did not obtain a preliminary decree. That is one hurdle.
Well, preliminary decree is in fact
that declaration you did not obtain.
In fact, under the administration suit, there is also scope for preliminary decree.
Yes, but for the last 60 years, you did not obtain.
Parties did not obtain, but it does not mean the court cannot finally put an end of this litigation.
That I have to see regularly.
That does not mean, but if the language of 35 Calcutta is borrowed, where Lordship has seen there is also not spoken about of any preliminary decree. They have spoken only to this extent that you meet the liability of the creditors first. After meeting the liabilities, whatever residue property is in the hand of the administrator, that property to be given to the legatees or to the heirs, either according to the will or otherwise. Now, what is otherwise? Otherwise is the parties have agreed by themselves to divide the properties in 3 lots. Lot A, Lot B, Lot C. So now the administrator, what will do? He will formally record a minute, give it to these parties which will be recorded by the
Because
court
in
by
this
a
matter, one administrator is already appointed.
already appointed. From time to time, the personnel of the administrator changed.
administrator is there.
Administrator
Pending
lighter, pending lighter. From time to time, it was changed. Some of the retired judge of this High Court also the administrator of the same property. After his elevation, somebody else has come. So therefore, that is the whole object, my lord. My whole purpose of citing these two judgments are to that although this is purely not a partition suit.
Very well, you have cited two at least.
Yes.
The allegation was nil. You have cited nil.
In fact, I forgot to cite that judgment, my lord. I had these two judgments. When Mr. Ghosh said that Mr. Dotto has not cited any judgment,
Anyway, this is 1953 and 35.
These are the two judgments. But when I will give my note, in the note I will also refer
You deal
to
with
that.
this.
And I have said so today because so that he can deal with that.
Anyway, he will
be
deal with
taken
it
as
and
surprise.
complete it on the next day.
Next day. But I do not want to add anything else.
May Mr. Rupa Ghosh, my lord, finish his submission on the
So
next
if
day,
you can
and may I
complete
also
it,
complete on that
if
date.
you can complete it before 12,
Yes, my lord.
it will be easy because
Yes.
thereafter 2 weeks this bench may not sit.
Yes, may we have opportunity to deal? May I have the opportunity?
No,
to
he
deal
will
with-
reply, comprehensive
on
reply.
that day itself. On that day itself, it can be. Yes, your lordship will kindly fix a date so that some time be given to us, at least an hour.
একটু দেখুন তো সিদ্ধার্থ বাবু
তুই এক
আছে
ঘন্টা
নাকি?
বলবি?
Yes, learned advocates for the parties are present. Hard learned advocates. As the hearing could not be concluded, let this matter appear on.
দশ সাহেবকে করতে দেবে আমরা আগে থেকে বলবো
এইখানে ডায়েরি
দেখুন তো 2 তারিখে কি 3 তারিখে ফিক্স আছে কিছু 2 তারিখে না 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 মানে হিয়ারিং এ কিছু ফিক্স আছে 2 তারিখে 2 তারিখে ফিক্স নেই টাইমিংস কিছু আই এম কিপিং ইট অন সেকেন্ড টিউসডে
My lord, kindly.
May it be at 2, my lord, so that we both get an opportunity.
Sir, kindly not put it at 3 o'clock. My lord, 3
আচ্ছা
o'clock is very
দুটো
uncertain.
তাহলে দুটোর সময় অ্যাপেলেট সাইডে কিছু ম্যাটার নেই তাহলে সেকেন্ড let this matter appear for further hearing on 2/12/2025 at 2 p.m.
Deep to obliged.
Mr. Ghosh will take half an hour.
এই appellate side matter আছে
I will not take anything.
yes appellate side matter is there any is it an extension yes what do you say is it extension of
Only
interim
one order is required with respect to 6 items.
yes please yes is it extension of interim
Proceedings are there.
yes
Only expedited disposal prayer, my lord, it is applicable in all 6 matters.
all the 6
All 6.
দেখি রেকর্ডটা দেখি
Same. So one single order will do in respect of all 6 matters. So what had happened? 143 application was filed by the complainant in 130 proceeding. That was turned. Challenging that we have come here. Now, my lord, if it is disposed of and he comes, it will take lot of time. So, my lord, only one direction I am seeking, that it is disposed of within 3 months because 130 proceeding, he has already appeared, he is participating. Then my entire purpose will be served.
yes
138 proceeding. Copy of sir, these are the affidavit of sir.
yes where is your prayer
The prayer was 143 application was turned down. That your lordship will be finding at page number.
you are the complainant
I am complaining. So I am suffering. He is not coming. So my lord, only one thing, one direction. Let the entire application be disposed of within 3 months. All matters.
so notice is issued upon the other side
All copies are there. If your lordship want to see, application
yes record an order learned advocate for the petitioner is present learned advocate for the petitioner submits that the petitioner is not challenging the order passed by the learned trial court on merits, but he is praying for an expeditious disposal of the complaint case being number 1392 of 2020, pending before learned, which learned Judicial Magistrate 6th Court at Alipur expeditiously. Stop. In view of such facts, this application stands disposed with a request upon the learned Judicial Magistrate 6th Court Alipur to dispose of the complaint case number 1392 of 2020 expeditiously and preferably within a period of 6 months from the next date fixed.
The same order in all 5. All those are connected, same party. 130.
But the case number will be different.
Case number will be different. They will take from there.
Same judicial magistrate.
Same.
আচ্ছা ওই অন্যগুলো আর কটা আছে? Yes, item number?
Item number 6, 7, 8, 9, 10.
এটা 6 হলো, তাহলে 7, 8, 9, 10 একই অর্ডার করবেন, বাট দি কমপ্লেন্ট কেস নাম্বার উইল বাট কমপ্লেন্ট কেস নাম্বারটা শুধু চেঞ্জ হবে।
हाँ दे दे भाई दे दे दे।
Excuse me?
अच्छा दो तो
এটা নিয়ে যাবে, হ্যাঁ।